Committee on February 8th, 2022. This morning, we have three public hearings on LD 1934, LD 1905, and LD 1926. I will be running the first hearing on LD 1934, and then we'll be turning it over to our colleague, Representative Babich, to run LD 1905 and 1926, as I will be introducing those bills. So I'm going to start by having committee members introduce themselves, and I'm just going to go around my screen as in the order that I see folks, starting with Representative Poirier.
Thank you, Mr. Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you, Representative. Representative Thorne.
Good morning from Carmel. Thank you, Mr. Chair. My name is Jim Thorne. I represent House District 103 up in Carmel, Herman, and Etna in beautiful, snowy Penobscot County.
Thank you, Representative. Representative Babich.
Good morning. My name is Christopher Babbage. I did my Tim Conway old man impression as I went down my driveway to get my newspaper this morning, which is in District 8, most of the town of Kennebunk.
Thank you, Representative. Representative Sheehan.
Thank you, Mr. Chair. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Thank you, Representative. Representative Moriarty.
Good morning, all. I'm Steve Moriarty, representing Cumberland and part of Gray in District 45.
Thank you, Representative. Representative Galgay-Reckitt. You're muted, Representative.
Good morning. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland.
Thank you, Representative. Representative Evangelos.
Thank you, Mr. Chair. Good morning, everyone. Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thank you, Representative. Representative Newell.
Thank you, Mr. Chair. Good morning, everyone. I am Rena Newell, and I serve as the Passamaquoddy Tribal Representative here in Sabayak, and we have an icy morning here in the Down East.
Thank you, Representative. Representative Libby.
Thank you, Mr. Chair. I'm Laurel Libby, and I represent District 64, which is part of Auburn and all of Minot. And I will be here today, but you will see my camera covered often as I have kiddos home from co-op today due to the weather.
Thank you, Representative. And my Senate co-chair, Senator Carney.
Thank you. I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And I will be in and out this morning for some other committee work. Thank you.
Thank you, Senator. And my name is Tom Harnett. I serve as the House Chair of Judiciary. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside. And I will begin by asking Supi if we have the bill sponsor on LD 1934.
We do, and I'll move her right in.
Very good. So I will wait for the bill sponsor to come over. Welcome, Representative Talbot Ross. Nice to see you again. I will begin by opening the hearing on LD 1934, which is a resolve changing the identifying and reporting responsibilities and extending the reporting deadline for the identification of places in the state with offensive names. And I would welcome to the Judiciary Committee the bill sponsor, Representative Talbot Ross.
Thank you, Representative Harnett. Good morning. Senator Carney, Representative Harnett, and the honorable members of the Joint Standing Committee on Judiciary. I am Rachel Talbot Ross. I represent House District 40 in Portland and serve as the Assistant House Majority Leader. Thank you for the opportunity today to present LD 1934, Resolve, changing the identifying and reporting responsibilities and extending the reporting deadline for the identification of places in the state with offensive names. The purpose of this bill is to entrust the Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations with responsibility for furthering and pursuing the tasks outlined in the predecessor Resolve LD 1591, for which a report was submitted to this committee on December 21st, 2021. With a new reporting deadline of December 1st, 2022, which this bill calls for, the Permanent Commission will review existing law in view of expanding the definition of what constitutes an offensive name. We'll also explore methods of identifying individuals and entities that benefited historically from the global economy of enslavement. Additionally, LD 1934 empowers the Permanent Commission to create an advisory committee on reconciliation and place names within the Commission in the interest of accelerating the eradication of offensive place names. In 1637, British colonialist John Jocelyn traveled through the areas we now know as Maine and Massachusetts, detailing his encounters with enslaved Africans in the region. When he arrived at Cape Porpoise in Kennebunkport, Jocelyn found a fisherman baiting his hooks with a, quote, drowned Negro's flesh. This horrific scene is one of the earliest accounts we have documenting Maine's Black history. Just across the harbor from Cape Porpoise is a place that still in 2022 is called Negro Island. Islands bearing the same name dot the Maine coastline from Castine to Camden to Biddeford. Until very recently, other islands bore the N-word in their official names. Offensive place names such as Negro Island or S-word mountain are vestiges of a history of violence, exclusion, expropriation, marginalization, and dehumanization. But they have lost none of their potency over the decades and centuries. Racial slurs inscribed on Maine's landscapes and maps perpetuate the sense that Black and Indigenous people are still not safe or welcome in these areas. Members of Maine's historically marginalized communities have long bristled at these terms and have led persistent campaigns over the past 40 years to rid our state of such slurs, beginning with my father, the Honorable Gerald E. Talbot. Yet even when these civil rights and tribal leaders have managed, as elected public officials, to pass legislation in an effort to eradicate offensive place names once and for all, flaws in the system have undermined those initiatives. 43 years after LD 1661 was signed into law, 43 years later, I learned with great consternation that my father's landmark 1977 bill had never been effectively enforced. Through our work, however, on 1591, a collaboration between the Department of Agriculture, Forestry, and Conservation and the Permanent Commission, we learned that existing methods of identifying and replacing offensive place names in Maine require the public to take initiative and to engage a convoluted process that few officials understand, navigating a confusing labyrinth of state and federal agencies. In these conditions, things can easily slip through the cracks, and they routinely do. Take, for instance, the case of, quote, White S-word Island. It was renamed to No Name Island circa 2000-2001, though it seems the U.S. Board of Geographic Names never received notice about the change. There are currently 3 established methods of effectuating a name change in the state of Maine. 1, an individual or municipality can directly petition the U.S. BGN. 2, an individual or municipality can file a complaint with the Maine Human Rights Commission. Or 3, An individual or municipality can appeal to the state name authority at the Office of GIS at OIT. I know I'm using a lot of acronyms here. The Office of Information Technology. Nowhere outside of statute does there exist a roadmap or guidelines to inform the public of these options. Moreover, the person vested with the title and responsibilities of the state name authority, that person for the state is serving in a volunteer capacity. Volunteer. Offensive place names emerged from a history of racial violence and oppression. The work to rid our landscapes and maps of derogatory terms needs to be firmly grounded in a comprehensive understanding of that history and informed by the lived experience of the impacted populations. When offensive names exist in the public domain, the public must be engaged in the process of redressing historical wrongs. 3 bills and 40 years have not been sufficient to eradicate derogatory and racially offensive names from our landscapes. I have designed this 4th bill as an effective means of creating needed and lasting change. I thank you for your consideration and for listening so intently. I would be happy to answer questions you may have for me. And I'm pleased to say that Steve Dixon and Dr. Meadow Dibble, Steve Dixon is with the Department of Agriculture, Conservation and Forestry, Dr. Dixon and Dr. Dibbles with the Permanent Commission. The 3 of us have served as kind of a team over the last year in trying to address this, and you'll hear from them later. They're extraordinary champions of this work, and I wanted to acknowledge them now, and also just remind this committee that you do have a report that was submitted detailing the work that we did over the last year. Thank you again.
Thank you very, excuse me, thank you very much, Representative Talbot Ross, for bringing this matter forward. Are there questions from committee members for the bill's sponsor? I will look through the room and ask you to please raise your electronic hand if you do have a question, and I will begin with Representative Reckitt. You're muted, Representative.
Thank you for bringing this forward, Representative Talbot Ross. I wanted to just ask you to remind me, I heard you say that the report that we received was in December of last year. Could you tell me the precise name so that I can look it up more easily?
Yeah, the report is dated December 20th, 2021. I'm not sure that's when you actually received it. The report would have come directly from DACF. So you may have received it earlier this year. And it really is a report of 1591, the bill that we're now trying to extend that work on. So it was LD 1591, and I believe Peggy may be able to either recirculate that or make sure that
you know what the link is. Right?
Got it. Yeah.
Thank you so much, Rachel.
Absolutely, Representative.
Thank you, Representative. Senator Carney.
Thank you. Thank you, Representative Talbot Ross, for bringing this bill forward. And I also just wanted to follow up on what Representative Reckitt said, commending people to look at the report. And we will, I know that it's publicly posted, and we will let members of the public as well know where they can find it, because it is a really important report and a lot of good research that went into it that everybody should have access to. Thank you.
Thank you.
Thank you, Senator Carney. Are there additional questions for the bill's sponsor by members of the committee? If so, please raise your electronic hand. Representative Babich.
Yes. No, I just want to commend Representative Talbot Ross for bringing this forward and enlighten me of a little bit of history that on a neighboring district that I was unaware of. So thank you for that.
Thank you.
Thank you, Representative. Representative Moriarty.
Thank you, Mr. Chair. Representative Talbot Ross, good morning. I think I'm in the same boat as Representative Reckett in that I don't recall having read the report from last December or having seen it, but that's not to say that I didn't get it. I just want to confirm that the bill before us today essentially does two things. It creates the Advisory Commission on Reconciliation, and it also extends the ultimate report date by 1 year to December of the current year. Other than that, it really doesn't seem to add to the charge of the permanent commission. Is it fair of me to say that?
That is correct. That is correct. Yeah.
Okay, that's good. Thanks. I understand. Thank you.
Thank you.
Thank you, Representative. Are there additional questions from committee members? Representative Babich and Senator Carney, I see your hands up. I'm going to assume they are latent.
It is. Thank you, Mr.
Thank you
Chair.
very much. I am not seeing any other questions from committee members. So again, I would like to thank the bill sponsor for bringing the bill forward and being with us this morning.
Thank you all.
I am now going to go to the attendee room, and I note that there are no other legislators who wish to speak on this matter. So I will turn to persons who wish to speak in favor of LD 1934 and ask you to please raise your electronic hand so that I can move you over. And I would ask the committee clerk to first move over Amy Sneerson, followed by Meadow Dibble, and then Stephen Dixon. So I will wait for those folks to come over. And I would remind people, when you testify, please give your name, place of residence, and any organization that you represent. And we will be using our typical rule of 3 minutes of testimony. I will be keeping track of that. I'll hold my phone up with about 20 seconds left, and then you will see when the time is up, I'll hold my phone up with a yellow sticky that says time. So with that, welcome Ms. Sneerson to the Judiciary Committee. Please begin your testimony when you're comfortable.
Thank you. My name is Amy Sneerson. I'm sorry, Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on the Judiciary. My name is Amy Sneerson. I'm the Executive Director of the Maine Human Rights Commission, and we're here to testify in favor of LD 1934, resolve that directs the Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations to continue the critical work started under 1591, as Assistant Majority Leader Talbot Ross described. And the report that was produced about 1591 was really spectacular, and I encourage folks to read it, to talk about why 1934 is important to have the Permanent Commission go forward with work, streamlining processes to address offensive place names that exist, because they do still exist. And as Representative Talbot Ross mentioned, one of the pathways that currently exists is through the Maine Human Rights Commission, which is, I think, why it makes sense for us to be working with the Permanent Commission, because we get very few. In fact, looking at our annual report for the last 10 years, it doesn't show any complaints having been resolved related to offensive names. And that may be because it's a not well-known pathway that exists. It's kind of obscure. It's tacked on at the end of the Maine Human Rights Act. And with all the respect in the world for Representative Talbot Ross, his father, who got this portion, who ensured that this portion would remain active in the Maine Human Rights Act, it just is not well known. And our agency has never had the resources to initiate our own complaints. We only have the staffing, and barely have the staffing, that lets us respond to complaints that are brought to us. We rarely initiate our own complaints. So we are really excited about the idea of having a proactive process that would let Maine folks address offensive names that exist. And we're happy to be a part of that as needed. That's really all I wanted to say, and I'm happy to answer any questions. And to thank Representative Talbot Ross for bringing this forward and the staff at the Permanent Commission.
Thank you very much, Ms. Sneerson. Thank you for being here today and sharing your thoughts with the committee. Are there questions from committee members for Ms. Sneerson? I will wait to see if anyone pops up their electronic hand. And I am not seeing any. So again, thank you very much for being here today. We greatly appreciate you taking the time.
Thank you.
You're welcome. I will next turn to Dr. excuse me, Dr. Meadow Dibble. Welcome to the Judiciary Committee. Please begin your testimony when you feel comfortable.
Thank you so much. Senator Carney, Representative Harnett, and honorable members of the Joint Standing Committee on Judiciary. My name is Meadow Dibble, and I am Director of Community Engaged Research for the Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations, which I'll refer to as the Permanent Commission. I am honored to offer testimony in support of LD 1934, resolve changing the identifying and reporting responsibilities and extending the reporting deadline for the identification of places in the state with offensive names. We extend deep gratitude to Representative Talbot Ross for introducing this bill, as well as its predecessor, LD 1951, on which the Permanent Commission collaborated alongside our colleagues at the Department of Agriculture, Conservation, and Forestry, and for which we submitted a report to this committee on December 21st, 2021. LD 1934 is a resolve that confers responsibility for its implementation on the Permanent Commission, an independent entity empowered by state law to advise and consult all three branches of government. On behalf of the Permanent Commission, I assure you that we welcome and wholeheartedly accept the opportunity to lead this work. Given our mission of examining racial disparities across Maine and improving the status and outcomes for currently and historically disadvantaged racial, Indigenous, and tribal populations, the task of performing research and deliberating to identify and eradicate offensive place names falls squarely within our purview. LD 1934 will allow the Permanent Commission to build on the foundation we laid under LD 1591 by pursuing the three tasks outlined in that bill, only in far more favorable conditions. In effect, this resolve endows us with two critical resources we lacked over the 48-day period during which LD 1951 was in vigor between October and December 2021. And those resources are time and human resources. To be certain, there is an urgency to eliminating offensive and dehumanizing names from Maine's landscape and maps, as they represent unconscionable human rights abuses. If such racial slurs were scrawled on school walls, for example, authorities would remove them immediately. At the same time, the process of defining, identifying, and eradicating those names is highly convoluted and challenging to navigate. Devising a streamlined approach will require careful planning, coordination among authorities, public education, and a sustained effort led by the communities most impacted by these names and by the history of racial harm from which they emerge. LD 1934 calls for the creation of an advisory committee on reconciliation and place names to be assembled by and housed within the Permanent Commission, with the mission of accelerating the process by which derogatory geographic names in Maine are identified and replaced.
Doctor, your time has expired. If you could wrap up, and there will be an opportunity for committee members to draw out additional information. Thank you.
Thank you, Representative Harnett. We at the Permanent Commission believe that the public deserves easy access at no cost to consultation in matters concerning offensive place names. And for that reason, we are prepared to assemble and house this advisory committee in the interest of providing a low barrier avenue for redressing these historical wrongs. I thank you so much for your time and your consideration on this bill. We respectfully urge you to support LD 1934, and I am happy to answer any of your questions and provide additional information.
Thank you very much, Dr. Dibble. We appreciate your testimony today. Are there questions from committee members for Dr. Dibble? If so, could you please raise your electronic hand, and I will begin with Representative Babbage.
I'm trying to mute myself. Thank you, Mr. Chair. Dr. Dibble, I just, the title of the bill deals with offensive names, but we're entrusting it to the commission, which is primarily trying to eradicate, well, the commission obviously is about the status of racial, indigenous, and tribal populations. Is it the intent to address ethnic insensitivity as we look at names across the state? I'm thinking of some minority groups across the state that may have street names and things of that sort that may be relevant.
Thank you so much for the question, Representative Babbage. Yes, in effect, the first task of an advisory body would be to expand the definition of what constitutes an offensive place name. When studying the history of this bill, it became clear that the definition of offensive place name in the original 1977 legislation put forward by Representative Gerald Talbot was very broad. So broad as to require further legislation to clarify the intent of that original bill and state very specifically these words are not to be used, and their derivatives are not to be used either. So there was a narrowing of definition, and what we feel, we realized in the process of studying all of this history is that expanding the definition of offensive place names is an important first step in this work to really consider all protected groups. Thank you. I hope that answers your question.
It does. Thank you so much.
Thank you, Representative Babbage. And if you could lower your hand, that would be great. Representative Moriarty.
Thank you, Mr. Chair. Dr. Dibble, I just have one question to clarify my understanding of the bill. The proposed advisory committee will in fact be a subcommittee of the permanent commission, and you're not proposing to go out and advertise and solicit non-commission members to make up the advisory committee. Am I correct in that reading?
Thank you, Representative Moriarty. I'm glad for the opportunity to clarify. The advisory committee would live under the permanent commission. It would be housed by the permanent commission. And while it would no doubt include certain members of the commission, it would invite onto the advisory board esteemed colleagues such as Dr. Stephen Dixon of the Department of Agriculture, Conservation, and Forestry, Director Amy Sneerson of the Human Rights Commission, Attorney General Aaron Frey, if that opportunity presents itself, and other scholars, community members with lived experience of racial trauma and with knowledge of these issues.
And do you have a feeling as to how large the advisory committee will be?
We haven't yet had that conversation, but in our experience, about a dozen people on a committee makes for a diverse group of voices, bringing important perspectives to bear on the work without being overly cumbersome.
Yeah, exactly. Anything above 12 to 15 gets a little unworkable.
Unwieldy, yes. Indeed.
Okay, well, thanks for clarifying that. I appreciate it. Thank you.
Thank you.
Thank you very much, Representative Moriarty. Thank you for your responses, Dr. Dibble. Are there additional questions from committee members for Dr. Dibble? If so, please raise your electronic hand. And I am not seeing any additional questions. So again, thank you very much for taking the time to share your thoughts with us this morning. We greatly appreciate it. And I would next recognize Dr. Stephen Dickinson. Doctor, as soon as you are ready, please begin your testimony.
Thank you. Senator Carney and Representative Harnett and members of the committee. My name is Stephen Dixon, and I'm the state geologist and the director of the Maine Geological Survey in the Bureau of Resource Information and Land Use Planning. I am speaking on behalf of the Department of Agriculture, Conservation, and Forestry in support of LD 1934, Resolve Changing and Identifying and Reporting Responsibilities and extending the reporting deadline for the identification of places in the state with offensive names. The department supports working with the Permanent Commission on the Status of Racial, Indigenous, and Maine Tribal Populations, the Commission, as a member of the Advisory Committee on Reconciliation and Place Names proposed in this legislation. DACF will help identify where in Maine offensive names in Title I, Section 1101 occur, and will collaborate with the Advisory Committee and others to change the offensive names by petitioning the United States Board on Geographic Names. In the past year, we worked together to identify the process of changing names with the goal of getting alternative names to the U.S. Board for timely consideration and revision. The department supports the proposed leadership of the commission. The Maine Geological Survey is prepared to help with cartographic identification of offensive names listed in Title I and to eradicate such names from state geological publications, state cartographic information publicly provided by the Maine Office of GIS, as well as those added to Title I in the future. Thank you for your time, and I'm happy to answer questions now or in the work session.
Thank you very much, Dr. Dixon, and I apologize for mispronouncing your name and lengthening it when I introduced you. Are there questions from committee members for Dr. Dixon? If so, please raise your electronic hand so that I may recognize you. Representative Babbage.
Well, thank you, Mr. Chair, and I will lower my hand right now.
Thank you, Representative Babbage.
Way to do it.
The committee breaks into applause. I apologize for that. Mr. Dixon, could you, this is interesting to me that there is a governing body, a federal body that must approve a name change of this sort.
Yes, that's correct. And you may ask why the Maine Geological Survey is even part of this. And there are two reasons, but the U.S. Board on Geographic Names is housed within the Department of Interior and next to the United States Geological Survey, which is responsible for making maps in the nation and therefore the labels of the places on those maps across the country. So in order to effect a change, it has to go to the board and they have to approve it. They also do their own historical research to the, let's say, the efficiency or the appropriateness of substitute names that get placed in the geography of the United States. So there's that point. And the second point is that we at the Maine Geological Survey use those federal maps as base maps for some of our geologic products. And we want to make sure that even those historical products get cleaned up and have names changed or at least removed in the interim until the federal board makes their decisions to change the names.
Thank you very much. That's very helpful.
Thank you, Representative. Are there additional questions for Dr. Dixon? If so, please raise your electronic hand. And I am not seeing any. So again, thank you very much, Dr. Dixon, for your testimony and your willingness to participate at an upcoming work session. We greatly appreciate your time.
Thank you.
Now, I don't have anybody who signed up to testify in favor of the bill, but I will go back to the attendee room to see if there is anybody who would like to be heard in support of LD 1934, to please raise your electronic hand. And I am not seeing anyone, so I would now ask if there are any person or persons in the attendee room who would like to testify in opposition to LD 1934, to please raise your electronic hand. And again, seeing none, I would ask if there are any persons in the attendee room who wish to speak neither for nor against LD 1934. If so, please raise your electronic hand. And I am not seeing any, so having heard testimony from all those present who wish to testify, I will again thank the bill sponsor for bringing this matter forward and close the public hearing on LD 1934 and turn over the gavel to my colleague, Representative Babbage.
There. Thank you. Thank you, Mr. Chair. The Committee on Judiciary will now entertain. We will have the public hearing on LD 1905. And it's my pleasure to ask our distinguished chair to come forward and testify and introduce himself to this body.
Thank you very much, Representative Babbage, Senator Carney, and colleagues on the Judiciary Committee. My name is Tom Harnett, and I represent House District 83, which includes the town of Farmingdale and the city of Gardner. Today, I'm here to introduce LD 1905, an act to facilitate communication between prosecutors and unrepresented defendants while protecting the rights of those defendants. This bill was submitted by the Criminal Law Advisory Commission, known as CLAC, and the bill makes technical changes to a statute we enacted last session to facilitate implementation of that law while also protecting a defendant's right to counsel. Specifically, this bill makes the following changes. One, it limits prohibited communications between a prosecutor and an unrepresented defendant to those communications concerning the facts, circumstances, merits, or disposition of a pending criminal charge against the defendant. Two, it prohibits any communication between a prosecutor and a defendant other than those specifically addressed in numbers 3 and 4, which I will discuss, before and until the defendant has been informed by a judicial officer of the defendant's right to counsel, including court-appointed counsel if the defendant is indigent and has waived the right to counsel in each prosecution pursuant to rules adopted by the Supreme Judicial Court. 3, it allows a prosecutor to communicate with an unrepresented defendant to offer the defendant an opportunity to participate in an established pre-charge diversion program, the successful completion of which would result in the prosecutor not prosecuting the charge or charges against the defendant, or to notify the defendant that a pending criminal matter is being dismissed. 4, it does not interfere with the obligation of the state to provide discovery or other information pursuant to court order, pursuant to rules adopted by the Supreme Judicial Court, or otherwise required by the Constitution of Maine or the United States Constitution, or the ability again of the prosecutor to notify a person that no charge is being filed. A representative from CLAC is here to give you a more detailed explanation as to why they believe these changes are necessary. And while I'm happy to entertain questions, you might wish to defer those questions until after you hear from the representative of CLAC. I thank you very much for the opportunity to present this bill on their behalf for your consideration. Thank you, Representative Babbage.
Thank you very much for that introduction of LD 1905, Representative Harnett. Are there any committee questions for the sponsor? Seeing none, thank you so much. And Peggy or Soupy, if Ms. Ustak is in the queue, could you move her forward? Good morning. And
Good morning, Representative Babbage.
good to see you again. And could you please introduce yourself and then help us to understand this bill? Thank you.
Yes, thank you. Good morning, Representative Harnett, Representative Babbage, and honorable members of the Joint Standing Committee on Judiciary. My name is Laura Ustak, and I am here today on behalf of the Criminal Law Advisory Commission to present and recommend LD 1905 to you. Thank you to Representative Harnett for presenting this bill on behalf of CLAC and for your very detailed summary of the bill. I think you've done much of my job for me already this morning. CLAC submits this bill to make technical changes to Title 15, Section 815, enacted by the legislature very recently pursuant to Public Law 2021, Chapter 480. That was called an Act to Protect the Rights of Indigent Defendants. This bill is not meant to change the substance of the protections guaranteed by that statute. In fact, a more accurate title would be an act to facilitate implementation of the law regarding communication between prosecutors and unrepresented defendants while protecting the rights of those defendants. And that's on me. I should have paid more attention during the drafting process and inserted those extra few words into the title. Both prosecutors and defense counsel brought to our attention certain logistical realities associated with implementing Section 815. From reports available to us, prosecutors and courts have been very cautious about ensuring that the letter of the law is followed. And the Maine Commission on Indigent Legal Services helped to make that happen as well. Along the way, however, there were perhaps some unintended consequences of slowing court processes and the ability of defendants to get access to basic information about scheduling, discovery, and the status of their cases. And just this morning, I took a look back at the testimony on then LD 1685 and noted that this was actually anticipated in the testimony of the Maine State Bar Association, which they set out in their testimony that the implementation needs to be, quote, carefully developed so as to not to interfere with the resolution of defendants' cases. And I think that may be one of the unintended consequences that we're seeing. So LD 1905 is offered to facilitate implementation of Section 815. And what it does is it makes explicit some of what may have been implicit in the current version of the law. Accordingly, the bill sets out a clear exception that allows a prosecutor to notify someone that a charge is being dismissed. It also clarifies that the law does not apply to the provision of discovery or to notice to a person that no charge is being filed. The bill also allows the Supreme Judicial Court, by rule, to establish an appropriate procedure pursuant to which a defendant may waive the right to counsel. This would encourage the use of a uniform process throughout the state and enable the court to account for circumstances such as remote appearances, while still protecting the integrity of the constitutional right. CLAC drafted this bill with input from both the prosecution and defense bar, and the executive director of the Maine Commission on Indigent Legal Services and the sponsor of the original bill participated in the CLAC meeting at which language for the bill was finalized. And I thank them both very much for that input. It was very helpful both to CLAC, and it ensured that we stuck with our intention of not changing the substantive protections that the recent enactment put into statute. It's our understanding that both the sponsor and the director of the Maine Commission support the bill as a means to make operational improvements to this process, while continuing to protect the rights of the unrepresented defendants. That's all I have at this point. I'd like to thank you for your attention and the opportunity to present the bill. I'm happy to respond to any questions you have now, and I will do my best to be available for any work session.
Thank you. Excuse me. Thank you very much, Ms. Ustak. We certainly, this committee is certainly appreciative of all the work that CLAC does for us and for the state of Maine. May I ask before I go to the committee, if in your I don't know if it's consultation or participation of both the prosecution and defense bar, was there dissent or is this a consensus recommendation? Or I just want to clarify that.
You will never get consensus from everyone on both sides, across the board. I think there are some defense counsel who thought the law was just fine the way it was, and that obviously prosecutors can provide discovery, and that doesn't need to be stated explicitly in the statute. On the other hand, you have prosecutors who are very concerned about not complying with the absolute letter of the law, and that it might be interpreted very strictly against them. So they've been super cautious about not having any communication. And I think what's happened is it's slowed things down. There was also in the discussions in CLAC, there was one defense attorney who said, well, we don't need to put all of this in statute. We don't need to be super strict about it because we're dealing with adults who can make their own decisions. I'm paraphrasing very loosely here, but I think he thought that the statute may have been overprotective in some respects. But there's no dissent that there's no feeling that the law should come off the books or that it needs to be changed in substance. I think everybody was generally in agreement that these tweaks could be helpful to help it work more smoothly. I haven't spoken to all members of defense and prosecution, so I don't know what individual opinions will be.
But you are comfortable with characterization of these changes as technical?
Yes, the one thing I would point out to you is that the current statute says that the waiver has to be written. And this proposal would allow the Supreme Judicial Court to develop rules as to how the waiver could be accomplished. So it is possible that the Supreme Judicial Court could adopt a rule that says, for example, the defendant could waive the right in open court orally after being advised of the rights.
Thank you. Are there questions from the committee for Ms. Ustak? I see Representative Moriarty. Thank you.
Thank you, Mr. Chair. Good morning, Ms. Ustak. I just want to be sure I've got your correct professional title down. You are an Assistant Attorney General, I believe.
I am an Assistant Attorney General. However, I am not here this morning speaking on behalf of the Office of Attorney General.
Right, understood. Okay. I have three very short questions dealing with paragraphs 1, A, B, and C in sequence. Subparagraph A refers to a judicial officer notifying an indigent individual of the right to counsel. Who falls under the umbrella of a judicial officer?
I believe that would be a judge of the district court or justice of the superior court. But right now we have a unified criminal docket, so everyone wears the same hat.
All right, well, that leads me to my second question with reference to the first line of subparagraph B, where it clearly says the court has provided to the defendant a statement of rights and so forth. So are the two terms synonymous? And if so, should the same term be used in both subparagraphs?
I think that would probably be okay. I would want to work with Peggy on that just to make sure that I'm not inadvertently leading you astray. But that internal consistency might be helpful.
But when one uses the term court, you are referring to the presiding judge or justice, as the case may be.
I think in this case, that's wise. Sometimes those duties are delegated to a court clerk, but I don't know. I'm sorry. I'm just not able to answer it in your question because I think some of these things might be teased out in rule.
Right.
For example, if the person walking into the courtroom were handed a piece of paper with a list of rights, and then the judge confirmed that the person had read through them, understood them, had agreed with them, so it would still be happening, I think, by the judge.
Okay, I think it's something that perhaps could use some clarification, just because alternative terms are used.
Agreed, and thank you for pointing that out. And I think if I agree with you.
Okay, all right, and then finally, reference to subparagraph C, when a law enforcement agency advises a person of his or her Miranda rights, and the person then waives them, do they customarily get a signed sheet in which the accused agrees to waive the rights?
It depends on the situation, but very often there's a card or a piece of paper, and there may be initials next to each right as it's stated, or it may be taped, and the officer will ask the person, okay, I've read this, I've told you that you don't have to answer questions if you don't want to. What does that mean to you? So sometimes the officer will have the person state it back, or will ask if you understand. So sometimes there are initials, sometimes it's signed, sometimes it's recorded, sometimes it's all of the above.
Okay, that's helpful. Thank you very much.
Thank you, Representative Moriarty. Are there other questions from the committee for Ms. Ustak? I was going to address you as Assistant Attorney General, but I didn't know if I should, given who you're speaking for today. But
that's fine. I just always need to make clear which hat I'm wearing when I'm speaking.
Yes, well, thank you for being with us. I'm not seeing any more questions, so thank you very much for your testimony.
Thank you.
Are there others that would like to speak in favor of LD 1905 that would like to be brought forward? I don't have a look at the queue, but I'm not seeing any indication of that. If there are no others to speak in favor, then I would ask, are there any who are opposed that would like to speak on LD 1905? Seeing or hearing none. Are there any that would like to speak neither for nor against LD 1905? So at this point, if there is no other testimony to be brought before the Committee on Judiciary, I will call the public hearing on LD 1905 to be closed.
Representative Babbage, there were three.
Yes.
There were three hands up to testify neither for nor against.
Not in my queue. So I am very sorry about that. I needed that directive. What and to what will they testify? In favor?
They were neither for nor against, I believe.
Thank you so much for that. And my great apology. Without objection, we will reopen the public hearing on 1905 so that we can hear from Ms. Neto and Mr. Andrus And is there another? No. I saw Ms. Neto first, so if you'd like to testify, Ms. Neto, please proceed. And I certainly apologize. I didn't intend.
That's okay. I know we're still learning Zoom every day. My name is Tina Nato. Good morning, everyone. I am the Executive Director of the Maine Association of Criminal Defense Lawyers, and I am testifying in that capacity today, neither for nor against this proposed legislation. Essentially, it comes down to this. This committee passed and the legislature approved and enacted a law last year. That law is clear. That law is unambiguous, and that law is sufficient. The proposed changes do nothing to advance the substance of that law. I think there is a confusion with prosecutors as to who is a defendant. A defendant is someone who is facing criminal charges. A defendant is not someone who has a case that's been dismissed or a case that has been, in our parlance, no complainted. So prosecutors are not prohibited from having contact with those people in the first instance. I think Ms. Ustak referred to, or perhaps Representative Harnett, regarding the provision of discovery to criminal defendants. That is a constitutional requirement. There is no statute that needs to be enacted that allows that to happen. That is not communication, that is a constitutional mandate. So the confusion, I think, has been entirely generated by prosecutors themselves in the interim. We are not here to make the job of the courts or the prosecutors easier. Constitutional rights can take time. Making sure that they're protected can be very time consuming. That is the whole concept of due process. Things take time because they matter. And if we are going to allow any contact between prosecutors and uncounseled defendants, it has to be narrowly tailored. And I think the original bill did that for both pre-charge established diversion programs. And that's all that needed to be said, because the other people that have been included in this bill are not criminal defendants by definition. I think this bill actually moves away from the letter of the law that the Sixth Amendment Center recommended. The law as it currently stands was a reflection of those recommendations by that center. So to cut against it, to finesse it, I guess is the word that's been used, actually doesn't do anything to further the goals, which is to ensure that uncounseled defendants are protected from prosecutors speaking to them. I know we want to think everyone is on the same side here of justice, but there's a reason why we have this in place. People, no matter if they're adults or not, can be coerced into doing things that are against their best interests because they just don't know. That's why things have to be knowing, they have to be voluntarily made, and they have to be intelligently made. So that is why we oppose, I guess, the technical changes of the bill. We don't oppose the bill because it still furthers, I think, the goal of mostly protecting unrepresented defendants. But it's not necessary. And I think the current bill is a lot cleaner. The current law, sorry, is a lot cleaner. So I'm happy to answer questions to the extent I can, but I know for practicing defense attorneys, the current law is a good law. So with that, I would turn it over to anyone with questions.
Thank you, Ms. Neto. Are there questions for Ms. Neto from the committee? Yes, Representative Evangelos.
Thank you, Mr. Chair, and good morning, Ms. Nato. I just had a couple of quick questions. The first is, do you know what the composition breakdown is on CLAC between defense counsel and people affiliated with the prosecution?
Good question. I know there are 4 people who do defense-related work who are on CLAC. There, I think, are 4 prosecutors, and there are 4 either judicial officers or similar that I think, shall we say, have a prosecutorial bent, but the actual composition, I think, is supposed to be equally divided.
And just tapping into your line of thinking, I know the good work you do. Do you think Maine needs a criminal law reform advisory commission?
A criminal law reform. I mean, speaking on behalf of Maxwell, I don't know. I think criminal law revolution would be more appropriate at this point. But CLAC is not supposed to be partisan. It's not supposed to endorse, you know, necessarily one side over the other, but more how this would actually work in practice or conform with the code. As someone who attends these meetings regularly, sometimes that happens, sometimes it doesn't. I admire a lot of the work that's done with CLAC, but at the same time, I think this is coming out of cries from prosecutors, not defense counsel.
Well, that was the reason why I asked. That's been my experience as well. I didn't use the word revolution, but probably most of the people in the committee would imagine I wanted to, but I'll leave it at that. Thank you.
Thank you, Representative Evangelos. Are there other questions from the committee for Ms. Neto? Seeing none, I will reiterate my apologies, Tina, and it's important to hear from Macdel on this issue, so I appreciate very much you.
Thank you.
Having the opportunity. Yeah, thank you. Mr. Andrus, are you still on? I'm looking. Yes.
Yeah, good morning.
Would you like to give us some testimony? Mr.
Yes, and I'll be very brief. Thank you very much. Good morning.
Thank you.
I am, for anyone watching who doesn't know me, I'm the Executive Director of the Maine Commission on Indigent Legal Services. I know the committee knows me. The commission itself did not take a position on the bill, which is why I am testifying neither for nor against. From my perspective as Executive Director, I actually share Director Neto's comment that most of what is made permissive by this bill is already the case. I agree, for example, that prosecutors should be giving out discovery under the existing bill. It's a constitutional right, can't be legislated away. But nevertheless, from an operational perspective, we are in fact finding that prosecutors are using the bill in ways that we didn't anticipate. So from an operational perspective, the shortest route to my indigent defendants getting what they need does lie through these changes. And so from an operational perspective, I do support it. I think that's the extent of really the comment. The changes are technical, whether they're necessary or not. If they free the prosecution up to do what they are supposed to be doing, then they will make lives better for our defendants. If there are any questions for me, I'm happy to answer them.
Thank you, Mr. Andrus. And could you help me to understand from your perspective again, what is that operational perspective that prosecutors are taking?
Sure. And so once it became the law that prosecutors were not to speak to unrepresented defendants, they began referring those unrepresented defendants to our office. Courts have been doing the same, and some other entities as well. We've established a separate specific telephone number and landing page on our website with a web form, and we're working on other resources so that those folks can get funneled to us in a manner that allows us to address their questions and concerns. Some of the things we'll do with that will include getting early assignment of counsel or interfacing with courts or with district attorney's office to do some early stuff to assist people. Two of the primary sets of calls we get, the first relate to people having called the court, having learned that the court doesn't have a date scheduled for them, and then having to determine whether that's because the state has decided not to prosecute them or whether there's some other delay. The other common call is that somebody is unrepresented is trying to get their discovery. In my view, it's already the law that the state could tell somebody you're not in fact a defendant. They just simply wouldn't have been covered under the statute. The state could have answered the question. You're not being prosecuted. Practically speaking, most prosecutorial offices are not. Similarly, they should have been giving out discovery, but they haven't been. So operationally, from my perspective, while I would love to re-educate the prosecution and do their thing without this change, this is a means to the same resolution of helping get that information to the defendants, without them coming to us, and then we're unable to serve them because we don't have that access. We don't have a database that lets us see into the prosecutorial mind, that sort of stuff. And so that's what I mean by operationally. This will improve that flow. This will take away some of the impediments. These folks either getting resolution knowing their case is over, or getting discovery that allows them to begin assessing the case, or working with counsel early, or calling us with specific questions and saying, what does this mean? All of that will be allow us to provide enhanced client services directly at that early phase of the case.
Thank you for that, Mr. Andrus. Are there questions for the committee? Seeing none. Thank you very much for your testimony. Appreciate it very much. Are there others that would like to speak neither for nor against LD 1905?
Good morning.
Mr. Ruffner, welcome.
Good morning. Representative Babbage, Representative Harnett, members of the Joint Committee on the Judiciary, thank you for letting me provide testimony remotely today on this bill. I am speaking as also neither for nor against. And I think that there's some important things to consider when considering these amendments. I believe that the two individuals that testified prior to me are correct, that this is generated by the prosecution. And I think there are some amendments that would be necessary before the committee should consider endorsing these amendments to the original bill. One of which would be to make it clear that anything learned from the prosecution through any of these, or the state rather, through any of these allowed exceptions to the rule would not be used against an uncounseled defendant, either in this prosecution or another one. Every opportunity of contact from the state to an unrepresented defendant is a chance where an unrepresented defendant may unwittingly say something that hurts them down the road. And if we are carving out exceptions, it should not allow the state to use anything they learn in those exceptions. Also, the subparagraph 2A dealing with discovery is a bit of a Trojan horse. Traditionally, the state has included communications above and beyond mere discovery in their discovery packets. Invitations to come to the office before the first court date and discuss pleading guilty was one county's practice in communications they would send out to defendants originally. But in the discovery packet, there should not be offers to resolve the case, nor pleadings by the state to a defendant that haven't also been filed with the court. The state's discovery requests, requests for protective orders, things of that nature, they should be filed with the court first, but especially not offers. Offers from the state purport to tell a defendant what would happen if they plead guilty. They rarely, if ever, touch upon all the consequences that will flow to a defendant who chooses to accept the state's offer. In fact, the state isn't allowed to totally inform a defendant of what those would be, because that would be providing legal advice to a defendant. And they're not permitted to do that because they represent the other side. In fact, the court tries to warn a defendant of the collateral consequences, but oftentimes can't cover all of them. And that's why it's important that a defendant have the right to consult with an attorney before making these decisions. Maine has a history of trying to resolve cases far too early in the process. I was a prosecutor in St. Louis, Missouri, before I was a prosecutor briefly in Portland, Maine. I've been doing defense work for 21 years now. I was shocked at Maine's practice of trying to resolve a large percentage of misdemeanor cases at the first court appearances. In contrast, the only other jurisdiction I practiced was the city of St. Louis, not a rich district. The city itself is not a wealthy district, but its first appearances, they did not want to take guilty pleas. It was merely to inform a defendant of the charges against them in the process for either getting their own attorney or applying to the public defender. they weren't interested in, did not frankly have the time set aside, take guilty pleas at initial appearance. That is totally different from Maine. Maine keeps statistics on how many cases are resolved on at initial appearance. I know because the DA's offices in the past have shared them with me based on what happened in a particular lawyer of the day session. We need to be aware of that lens when we look at these proposed amendments, and we should be very hesitant to adopt them if they are either unnecessary or allow for loopholes in the original protections. I thank you for the time. I'll be happy to answer any questions today or in the work session.
Thank you, Mr. Ruffner. Are there questions from the committee for Mr. Ruffner? Representative Evangelos.
Thank you, Mr. Chair. Good morning, Rob.
Good morning.
These discussions that go on between a prosecutor and an alleged accused, how much leverage gets put on the accused by the prosecutor piling on all of these additional charges, leaving the presumed innocent defendant with some pretty rough choices? Is that a problem when they have these negotiations? You get a bunch of, you did one thing, but they charge you with 5.
Well, and to be fair, there may be one thing may have 5 different potential consequences under the law. So, but the entire process is coercive. It's coercive because, no one wants to come back to court again. And many defendants have the expectation that they won't have to in Maine. Just because of the culture of, we've been resolving so many of them at initial appearance, that's what they've learned from friends, family, colleagues, or asking around. Talking with a prosecutor or a judge is often intimidating even out of itself, even when the prosecutor is being completely appropriate, non-threatening, but for individuals who aren't in the system and haven't been there a lot, it is inherently intimidating. And to some extent, the more reasonable the prosecutor appears to be and actually is being, might lead a layperson to think they're really nice. They're being really reasonable. Perhaps I should just do this because I sense nothing in ill will from them. And it's not deception on the prosecution's part, but I have seen again and again and again your constituents leaving a courtroom having made a decision and not understanding the full consequences of that decision. It is not inherently clear, and there's no easy answer to it. But slowing down the process, making it making sure that the appropriate time and attention to detail is taken before these important decisions are made is one of the things we can do to ensure that there's less of your constituents that leave a courtroom after having made a decision and without understanding all the consequences that flowed from that decision.
Any more questions, Representative Evangelos? Thank you for that, and thank you, Mr. Ruffner. Mr. Ruffner, may I ask, are you seeing this as technical changes that have ramifications to which you're concerned and opposed, or do you see this as being more substantive and you're opposed?
I am opposed to some of the changes because I'm concerned. For example, as been mentioned by the two, both Tina Netto and Justin Anders, who testified before me, the prosecutors, of course, are allowed to comply with their constitutional obligation to provide discovery. I'm worried about what else may be snuck into that packet under the exception. For example, I am concerned about that we don't let the waiver of counsel happen too easily. It should take a long time for someone to waive their right to talk to an attorney when they are a defendant in a case before speaking to the prosecution, to make sure that a person understands those rights, has considered them. I just yesterday saw in Augusta an individual called up in arraignment, said, I don't want to talk to the lawyer today, I just want to plead guilty. And then she heard what the prosecution had to say, and then was suddenly like, well, maybe I should talk to the lawyer today. I think that's a sign that they hadn't really thought through all the consequences of what may happen. And that potentially they need to talk to an attorney for them to change their mind within 30 seconds. But absent them changing their mind, that guilty plea may have happened and they would have ended up doing a week and a half in jail. And so I don't think by and large that there's anybody who's trying to do it the wrong way, but we have a whole lot of history and momentum in one direction over the years that the way we think of these initial appearances, the whole idea of it slowing down the resolution of cases, that's not from my experience as a prosecutor and as a defense attorney in Maine. Slowing it down is in the beginning, at that initial appearance, that first time you're hearing of the charges and your rights, is a good thing. That event is happening too quickly with too many waivers of rights, with too little understanding.
Thank you for that response. Are there any other questions from Mr. Ruffner? Thank you very much for your testimony today.
You're welcome. Thank you.
Ms. Finn, good to see you. Would you like to speak today? Are you?
Good morning. Yes, I would, and I'll be very brief, Representative Babbage. Representative Babbage, Senator Carney, and members of the Joint Standing Committee on Judiciary. My name is Julie Finn, and I represent the judicial branch and have some very brief testimony, neither for nor against this bill. As you have heard, LD 1905 creates two exceptions to the law prohibiting communication between prosecutors and unrepresented defendants. Those are when the prosecutor wishes to offer the defendant the opportunity to participate in a pre-charge diversion program, or when the prosecutor wishes to notify the defendant that the pending charges are being dismissed. The judicial branch agrees that the changes proposed in the bill would streamline the current process, could facilitate early diversion programs that are already in place in several parts of the state, and in appropriate cases, provide necessary information to defendants. And that is all this morning. Thank you very much for your consideration. If I can, I'd be happy to answer your questions.
Thank you for that, Ms. Finn. Are there any questions from the committee for the representative of the judiciary? Seeing none. Thank you so much for your testimony. Appreciate that. Are there others that would like to speak neither for nor against LD 1905? I do not want to jump the gun, but I'm seeing none. So I think I can be confident at this time to bring the public hearing for LD 1905 to a close. And given that, the next on the agenda would be the public hearing for LD 1926. And I recognize the chair of the Committee on Judiciary, who is also sponsoring this legislation. Thank you, Representative Harnett.
Thank you, Senator Carney, Representative Babbage, colleagues on the Judiciary Committee. My name is Tom Harnett, and I represent the residents of House District 83, which includes the town of Farmingdale and the city of Gardner. I am here today to introduce LD 1926, a resolve regarding legislative review of portions of Chapter 301, fee schedule and administrative procedures for payment of commission-assigned counsel, a major substantive rule of the Maine Commission on Indigent Legal Services. As stated in the title, this resolve comes from the Maine Commission on Indigent Legal Services, Mickles, and is a legislative review of a major substantive rule. LD 1926 requires legislative review of one portion of the Mickles rules in Chapter 301. The rule we are reviewing makes final the amendment to the assigned council payment rate authorized during the last legislative session for implementation in FY 22. We amended Title IV, Section 1894 4D in July of 2021 to convert certain parts of Rule 301 to routine technical status, meaning that we do not need to review those. Under that amendment, however, the rules to establish the rates of compensation for assigned counsel and contract counsel remain major substantive and thus are subject to legislative review. In the final 2021 supplemental budget, LD 221, the legislature appropriated almost $6 million for each of FY 22 and 23 allocated specifically to increase the reimbursement rate for indigent legal services from $60 per hour to $80 per hour. In July of 2021, Mickles engaged in emergency rulemaking to make that rate increase effective immediately. Throughout the fall and early winter of 2021, they engaged in formal rulemaking to finalize implementation of that portion of the rule. And they completed their provisional adoption of the final rule in January of this year. This committee has repeatedly heard that one of the primary impediments to the ability of Mickles to effectively discharge its responsibility lies in the rate of pay available to counsel absent this rule change. The legislature indicated its assent to the rule change by making the appropriation necessary to fund that change. Mickles has implemented that change first through the emergency rulemaking and then through the provisional adoption of the final rule. This committee now must perform its task of enacting the rule in final form to give permanence to this necessary change. At an upcoming work session, we will work with the document that Peggy has provided us, which explains the steps we must take in approving or not approving a substantive rule change. A representative from the commission is here to provide the committee with details and answer questions. I ask that you defer questions until after you hear from the commission, as my job is simply to move this forward so that we can engage in our rulemaking responsibilities. I thank you for your consideration.
Thank you, Representative Harnett, for that. I actually have a question before we move on, and Representative, if you can answer it, fine. If not, I'd like to hear from the analyst. But we all know that major substantive implementation of past legislation comes before the legislature. Does it always require a new LD for that to happen? Is that I'd like that clarification if possible.
Well, this is the first time I've done this, so I'm going to turn it over to our analyst.
Right, thank you. The Judiciary Committee doesn't have a lot of major substantive rules within its jurisdiction, but the process for major substantive rules is the agency has to go through the rulemaking process, and instead of finally adopting the rules, they provisionally adopt the rules if they're major substantive. They have to go through the whole process, and then they submit it to the legislature by a deadline in January. If it's received by the Legislative Council by that deadline, then a resolve is created, and that resolve, it is a new bill each time or a new resolve each time. And anytime they amend those major substantive rules, it has to go through this process. You, as a Judiciary Committee, now that the bill has been presented, you have options about moving forward with the resolve. You can vote ought to pass, and then they can adopt the rules. You can vote ought to pass as amended and identify changes that you think need to be incorporated before the rule can be finally adopted. Or you could if you vote ought not to pass, because the the rules were submitted by the deadline, they can still adopt the rules. MCILS can still adopt the rules. The only way you can stop them from adopting the rules, if you really think they've done this completely badly and you don't want them to adopt the rules, you need to amend the resolve to withdraw the authority for them to adopt the rules. So it's really important for an agency to submit their major substantive provisionally adopted rules by the deadline, which MCILS did. And so this is the process for you as the legislature to review them. You don't have a lot of opportunities to review rules. This is your opportunity to review this rule and let it go into effect and be finally adopted, or make changes, or actually say, no, we want you to start over.
Thank you very much for that explanation, Peggy. It's taken me my 12th session in order to get that level of understanding, so I appreciate that response. Any questions for Representative Harnett regarding the introduction of LD 1926? Seeing none, thank you for your testimony this morning. Are there advocates that would like to speak in favor of LD 1926? Mr. Andrus, would you like to speak to us?
Yes, thank you.
Welcome.
Thank you very much. On behalf of MCILS and indigent defendants, and on behalf of our assigned counsel, we do respectfully request that the committee endorse this as ought to pass. The arguments we've made and the illustrations we've given you about the effects of the former pay rate, I think, have been covered pretty extensively. I'm happy to answer questions about them, but this committee was very receptive to us last year in hearing about those needs, and helped ensure that we get the appropriation we needed to be able to adjust the pay rate. We did the part that we could do through emergency rulemaking and through provisional adoption of the rule. But now we need you to do the part that only you can do, so that the increase in the pay rate that has been authorized through appropriation can also be paralleled in its authorization through rulemaking. I think rather than prattle at you, I'd welcome any questions about any details folks would like to know, but I know it's terrain that we spent a lot of time in.
Thank you. That's certainly true. Are there questions from the committee for Mr. Andrus? I think we'll let you off the hook, Justin. So thank you very much for being here today. And I will excuse you and ask if there, or you may stay on the panel, whichever your preference. Anyway, I will ask if there are others who wish to speak in favor of LD 1926. I'm not being given any indication that there are. Is there anyone opposed to LD 1926 that would like to testify before the committee? Seeing none, are there folks in the queue that would like to speak neither for nor against LD 1926? Mr. Ruffner?
Good morning again, representatives and senators on the Joint Committee on the Judiciary. I just want to start out by saying, in no way should my comments cause this committee to withdraw its support or withdraw authorization to the commission to adopt this rule change. It is a necessary rule change. But I wanted to speak neither for or against it to point out a couple of things. I am aware from attending the commission meetings that a number of the members of this committee drop in semi-regularly to participate or observe the commission's monthly meetings. And I appreciate the attention that the committee, whether or not you have time to attend those commission meetings, spends on this topic. This rule change is a small step in the right direction, but it's important to understand a couple of things. One of which is the current rate is not yet high enough. I don't want to spend a lot of time on it. It sounds self-serving coming from me, but I had a very difficult time and have been unable to, a number of times in the last 2 months, recruit new attorneys to our office to work on indigent defense issues because I cannot meet their salary expectations. Second of all, the method that we use, and I'm not talking about a public defender system, but the contract that we have with assigned counsel is antiquated and inefficient. The assigned counsel is only bills the commission for work done by assigned counsel, which leads to a underutilization or a complete lack of utilization of support staff that would make the legal services received of a better quality and provided more efficiently. For example, I have a contract as outside counsel for DHHS in probate cases for contested adult guardianships. Eliminating, not talking about the different rate, which is also very low. That contract allows my office to have support staff work on non-attorney things at the same rate under the contract. And that is because I believe the department has decided that by having support staff send out letters or draft subpoenas, they can do it much more efficiently than an attorney trying to peck away, as I do at my computer, and saves the department money overall and ensures that all the proper notifications go out efficiently. That system isn't allowed under the commission system. And so while I have brought on staff to help me with my department cases, I would be losing money even if the commission allowed me to use her at the paralegal rate. As some of you know, the commission wasn't even able to get any applicants for a state job at the current starting paralegal rate. It is virtually impossible for us to bring on new attorneys or support staff in a way that would better serve not only the indigent defendants, but also the state's taxpayers by providing the required legal services in a much more efficient manner if we had a more robust and contract with assigned counsel. Thank you very much.
Thank you for that testimony, Mr. Ruffner. May I ask for the support staff that do get reimbursed for their time? How do you report their time increments?
Well, this is a new contract that I have with the department, and it's by tenths of an hour. And the contract is that it's the same amount whether I do the work or whether staff does the work. Of course, in no way, shape, or form is any of the staff performing anything that requires an attorney to do the work, or are they practicing law? And it's always under the supervision of the attorney, in this case, myself, who has the contract. So it would be billed to the department. And in fact, that's one of the things she'll be doing is helping me on that. But it's reported to the department, and it's under tenths of an hour.
Thank you for your testimony. Are there questions for Mr. Ruffner from the committee? Seeing none, thank you very much for your testimony today. And I apologize for not introducing you a little more formally there.
Oh, that's fine. Thank you again. And thank you again
Absolutely.
for all the committee's hard work.
Are there others that would like to testify in LD 1926, neither for nor against? And I'm not seeing anybody. And if that's the case, then I feel comfortable bringing to a close the public hearing on LD 1926. I'll turn it back to you, Chair Harnett.
Thank you very much, Representative Babbage, for filling in on those two public hearings. Greatly appreciated. That brings the committee's work for this morning to an end. We will be in recess until 1 o'clock when we have, I'm just looking at my schedule here, 3 work sessions that will take up our the committee's time this afternoon. So I would ask all to please shut off your camera and mute yourself if you're going to keep the link open, and we will see each other at 1 o'clock. Thank you very
Senator
much.
Harnett?
Yes,
Good.
I'm sorry. Yes, Peggy?
I just wanted to let folks know that the report that the Department of Agriculture, Conservation and Forestry submitted back in December is now posted on our reports page for the Judiciary Committee. And I apologize that it wasn't up there sooner, but it's there now. And if anybody wants me to email it to them, I'll be happy to do that as well.
Thank you very much.
Thank you.
Did, before closing this morning's hearing, Supi, did you have anything that you needed to discuss with the committee?
Representative Evangelos had his hand up.
Okay, did not see that. Representative Evangelos?
I just wanted to take note of how quick our meetings go when Representative Babbage chairs them.
And I'm not going to point out that that's because he's not asking questions.
I think that's what I'm getting at.
Yep, okay.
Message understood.
Thank you. And his hand wasn't up either during the time. Thank you for that, Representative Evangelos. And with that, unless we have any additional stand-up routines, we will see each other at 1 o'clock this afternoon. Thank you.
Thanks.
See you in a bit.
And maybe him too, but Blackwell or Blackbird.
And Hannah Whalen, I can also bring in.
Good afternoon, everyone. I think we should be ready to go in just a couple of minutes, as if we're waiting for a few more committee members to return. All righty, it looks like we have a quorum. And so we can begin our afternoon's work. This afternoon, first, let's start by welcoming OPA analyst Janet Stocco, who is with us this afternoon. And I'll review with everyone what our work involves. We're going to start with, we have 3 work sessions, starting with LD 480, and then 1804, and then we'll finish with 840. And notice all of the 8s, 4s, and 0s in those bill numbers. We were laughing earlier today about that alignment. And I just also want to express thanks to Representative Babbage for chairing today's bill public hearing so well. Thank you, Chris. And all right, and so with that, we'll begin. We'll open our work session on LD 480. And Janet, if you could please give us the bill analysis, we'd appreciate that.
Certainly, if you don't mind, I'll share my screen again. My habit. So actually, Peggy staffed this bill for you in the first session. And when I went through her very helpful bill analysis and then the testimony and everything else, I just put together what I called a carryover update memo to try and remind you of what happened in the first session. But you may all remember, and it might have just been reminding me. So this bill, as you may recall, establishes a presumption that every adult who's the subject of a guardianship, conservatorship, or other protective arrangement proceeding is entitled to legal representation. And that means under that presumption, the county probate court must appoint counsel for any such adult who's not already represented by counsel unless the presumption is rebutted. But just to be clear, this presumption would apply in several types of probate proceedings. So as you can see in the bill, it applies, to initial proceedings to appoint a guardian, a conservator, or to establish a protective arrangement. It also, through cross-references that you can't see in the bill, applies to proceedings in which the adult seeks the removal of a guardian or conservator, an appointment of a successor, or to proceedings in which the adult seeks to terminate or modify the guardianship or conservatorship. So under the bill, the presumption that an unrepresented adult in one of those proceedings, who's the subject of those proceedings, is entitled to representation can be rebutted, and counsel need not be appointed by the county probate court if the court finds by clear and convincing evidence all three of the following: that the adult knowingly and voluntarily refuses such representation and does not wish to contest any aspect of the proceeding and does not wish to seek any limitation on the guardianship, conservatorship, or other protective arrangements that's being sought. If you compare that to current law, which if you were to click this link, it would bring you to the current law that Peggy gave you all before the first hearing. So under current law, for all of these sections of the bill, a county probate court must appoint an attorney to represent an adult in any of those proceedings if the adult requests that an attorney be appointed, or if the visitor who visits with the adult prior to the proceeding but is court appointed, that visitor is court appointed, if that visitor recommends the appointment of an attorney for the adult, or if the court on its own determines that the adult needs representation, or finally, if the court becomes aware that the adult seeks to contest any aspect of the proceeding or seek any limitations on the guardianship, conservatorship, or protective arrangement. It may be helpful to know that this bill doesn't affect, so keeps in place the law that specifies currently that unless the court makes a determination that the adult for whom the attorney is being appointed is indigent, in which case the county probate court would fund the cost of the attorney. So unless that indigency determination is made, the adult's own assets would be used to provide reasonable compensation to the attorney that's appointed. So that's helpful to remember, because oftentimes when we talk about court-appointed attorneys, we automatically think they're always paid by the government, and it's the court that's doing the appointing here, but the adult's own assets can be used if they have some to pay for that attorney, and only if that indigency determination is made is it then a government cost. And in this case, the government that pays is the county probate court. Looking through the testimony that Peggy that summarized in the bill analysis, and then you can click here to get to all of the testimony if you wanted to. The individuals and groups testifying in favor of the bill emphasized the constitutional rights and the fundamental liberties involved in guardianship, conservatorship, and other protective arrangement proceedings, and the importance of providing due process to adults subject to these proceedings, and that the way to ensure that that happens is through the appointment of an attorney. They also emphasize that this bill doesn't force an adult who's the subject of those proceedings to have an attorney if they knowingly and voluntarily do not wish to have one. And also they have to not want to contest the case. And then there were several individuals and groups testifying either against or neither for nor against the bill, and they raised several different concerns, including whether or how difficult it is to satisfy the clear and convincing standard of evidence, which could lead to expensive litigation on just this issue alone. Also, they were unclear from the language of the bill when the court actually makes the determination to appoint counsel. Is that at the outset before a decision is made, because the question has to be decided whether there is clear and convincing evidence of all of the factors. And so would you appoint counsel before then to be around during the determination of whether counsel is needed? Would you need a full hearing on that question? There are also concerns about the shortage of attorneys in various counties who are willing to accept court appointments, and the pressure that this bill might place, because it switches the presumption sort of to a default of appointing an attorney unless you find otherwise, as opposed to current law, which is you only appoint attorney if you find a factor in favor of the attorney being appointed. There was also a worry that the cost to county governments might constitute a state mandate. And the Department of Health and Human Services, Adult Protective Services submitted testimony with many of these concerns, but also indicating that under current law, their non-attorney employees are able to represent the department in certain public guardianship cases, and they would not they are not able to do so under current law if the case is contested. And there was a worry that if the presumption is flipped and more attorneys are appointed, would that automatically deem the case contested, and therefore their non-attorney employees could no longer represent the department in those proceedings. Just a reminder that you had requested information on the numbers of guardianship, conservatorship, and other protective arrangement proceedings in probate court. And you had 2018 numbers that were provided to you during the last round or last year looking at this bill. And over the summer during the probate study commission, we received 2020 updated numbers. So those are added here for you to compare and to see about how many cases there are in the counties currently. And then you had also requested information on why Maine chose to adopt the language that's in current law about when a probate court appoints an attorney in these cases. And Peggy had provided you information on the uniform law commissioners, uniform law and their uniform comment to that law. And so you can see that in her bill analysis that's on the last couple of pages. And then if you want to look directly at the uniform law, it's available here. And those are the pages that are actually on the PDF page numbered document. It doesn't, you need to look at the page numbers on the document that are printed because it doesn't exactly match the number of pages on the PDF, but you can then find those comments there. And just to remind you also, a majority of this committee did vote in favor of amending the bill to switch from the clear and convincing standard of proof to the preponderance of the evidence standard. And that amendment was then processed, and there was a fiscal note generated for the amendment that indicated both a potential state mandate, as the testimony had suggested, and that there would be a cost of a little bit more than $100,000 per year to the Department of Health and Human Services based on the language of the bill as amended. And the minority did vote not to pass. After you reviewed the language of the amendment and the fiscal note, Peggy's notes indicate that there was some concern about funding that fiscal note. And for that reason, you decided to reconsider and carry it over to then think about it again this year.
Thank you very much, Janet. Committee members, any questions for Janet? Go ahead, Representative Moriarty. Representative, we're not able to hear you.
Sorry, my fault. Thank you, Madam Chair. Janet, I was interested in your comments about indigency and as opposed to those individuals who have assets or means. That really isn't articulated in the bill as I see it, but presumably that comes from the broader statute, elsewhere in the statute.
Yes, it's under, I cited it in the memo. Let me double check so I don't tell you the wrong number. It's under section 5-119, subsection 1 of Title 18C, so of the probate code. And that's existing law and it's not changed through the bill.
So if I can follow up, Madam Chair, with just a couple of quick questions. Since there's existing law on that particular issue, as a matter of practice, when is the indigency determination made? Or is it not clear?
I do not know that. I am sure it is clear to people who practice probate law, though.
Okay, I'll bet it is. For those under guardianship with assets, a court would appoint an attorney, but the person under guardianship would pay from his or her own assets for representation. Is that correct?
Yes, what the law says is that the attorney who's appointed would be entitled to reasonable compensation using the property of the respondent. So that's the adult.
So that attorney would not be paid at the MCILS hourly rate, but at a reasonable professional rate for someone with probate experience or guardianship experience or what have you.
Actually, I don't know if the courts routinely just set the rate at the same as the MCILS rate or not. That may be a better question for the practitioners or the people in the courts.
Okay, okay, good. Thank you then.
Committee, excuse me, committee members, any additional questions for Janet? I am not seeing any. And let's see, I think the concern that Representative Moriarty raised is something we should look into. It also came up in the bill analysis, which is when would this determination be made? And I'm just going to see, I don't know if we have any practitioners in the attendee part of the meeting who are able to answer that. If there is anyone in the attendee part of the meeting who is a probate court practitioner, could you please raise your hand? And I am not seeing, oh, we have Lauren Willie, and I will bring her over. Thank you, Lauren. Lauren, thank you so much for joining the Judiciary Committee today. Could you begin with introducing yourself and just give us a bit of information about your practice with regard to probate law? And then if you could please answer our question, we'd appreciate that.
Sure. Good afternoon. Thank you for inviting me in. My name is Lauren Willie, and I'm a managing attorney at Disability Rights Maine. So we do a lot of work with representing people under guardianship.
Thank you. And then I think the question that Representative Moriarty had was, and you can correct me if I'm wrong, Representative, but is typically where in the process of a guardianship proceeding is the decision made as to whether or not to appoint an attorney?
So just to clarify the question, is that how it works now, or what I think this law is proposing, or either?
If you could answer both of them, please.
So right now, my understanding, and again, the process differs a little bit from probate court to probate court, but under the law right now, once a petition for guardianship is filed, and it is understood by the court that someone opposes the guardianship or has requested an attorney, or the visitor, if there's a court-appointed visitor, recommends an attorney, the court will appoint an attorney. So that could be right upon the petition being filed, or any point kind of thereafter, including at the hearing itself. If the court learns that someone wants an attorney for whatever reason, they may appoint an attorney then and postpone the hearing.
Okay, so I'm just going to ask a quick follow-up question to your very comprehensive answer. So in other words, a case could look like it was opposed from the outset, at which point an attorney could be appointed, or a case could look like there was no concern at the outset, and then later the judge might come to understand that there is an opposition, and that the person who's subject to the proceeding would like to or need to have an attorney.
That's correct. And I think, again, probably every probate court might have a little bit of a different procedure, but if it ever comes to the attention of the court that a person wants an attorney or it's being recommended, the law requires that they appoint one at that point.
Thank you. And then could you share with us your thoughts as to when it should occur with respect to this legislation?
So my understanding from looking at this legislation would be that the presumption that an attorney should be appointed to a person would really come into effect upon the filing of a petition for guardianship. So upon that initial, typically how it works in court is a petition gets filed, all the requisite documentation is often filed right around that time. And then the court will schedule it for a hearing. So looking at this law, it looks like the intent is that the attorney would be appointed for the person upon the initial filing of a petition to put them under guardianship.
Thank you. That's very helpful information. Committee members, any additional questions for Laura and Willie? Representative Moriarty?
Thank you, Madam Chair. I just would just follow up by repeating some of the questions I raised earlier. So, Ms. Willie, when is the indigency determination made? And for a person with assets or means, does the court determine the hourly rate for legal services?
That might be a better question posed to somebody else, but I can tell you that at least as someone who has a criminal defense background, in the district court world of criminal defense, what typically happens is the court will appoint an attorney, and then there will be an inquiry. They'll file a financial affidavit subsequently, and then the court after that will make a determination as to how that court-appointed attorney is going to get paid, whether it's through in criminal defense world or the MCILS. But so the attorney gets appointed, and then an inquiry gets conducted into whether that person qualifies for as an indigent person or not.
And that's what actually happens today? Or just, are you speaking about the idyllic version?
I don't know if that's how it happens in the criminal defense world. There's a
right, I know that.
So maybe Kathy Ayers, if she might know the answer better to that question. If I don't know if probate courts utilize financial screeners or people that are sort of specifically designed to kind of make that determination of people.
Okay.
Representative Poirier, would you have the answer to that question? No, okay. I would just say that when we can't talk about a bill that's not before us at this point, but we will be seeing a proposal related to what you've just asked Representative Moriarty in the future when we consider the probate judge bill, but that's not before us at this point.
Okay.
Thank you. Any other questions, Representative Moriarty?
Well, I guess I could ask one more unrelated to the previous ones. Ms. Willie, this is sort of a devil's advocate question, but is there any case law or court decision or something equivalent that compels us to provide representation in these various contexts?
I am unaware, having done no legal research on that particular issue coming into this. So I'm unaware of any case law. I'm happy to look that up if the committee would like to see if there's any case law. But I will point out sort of just the parallel of, how the Constitution requires court-appointed attorneys in criminal matters, and just pointing out that there have been courts that liken guardianship to the same sorts of liberty restrictions as under the due process clause of the U.S. Constitution. So I do think that there is a parallel there in terms of limitation on restrictions of liberty.
Yeah.
So I don't know if there's specific case law though likening that to guardianship.
Yeah, I see the parallel as well. The question though is this something that would be, in effect, nice and good for us to do, or are we forced to do it?
I don't know. I'm unaware if there's other states that have, just thinking about other states' case law, I don't know that there are other states that necessarily, I would imagine that most states, if it was constitutionally demanded, would have this presumption, but I definitely think it's something that is worth looking into, because I do think that this implicates a lot of due process concerns for people agreeing to guardianships without having adequate legal representation.
Okay, thank you.
Representative Poirier, go ahead with your question.
Thank you very much, Madam Chair. I'm hoping to get a little bit of clarification, just because what I'm hearing from you is that under this bill, there would be, like you say, a presumption upon filing. And if my memory serves me correctly, when we were hearing testimony previously when the bill was heard, how things work in probate now is that advocates actually speak to the individual and such before any kind of decision is made if a person needs counsel. So there's a little bit more in-depth process going on currently to decide if a person actually needs counsel or not. And I have a big concern about a person having choice because I've said it time and time again, I work with individuals with intellectual disabilities, and as a state and as a country, actually, there are a lot of things in place to provide individuals with disabilities the right to choice, just like you or I would have. And it seems like we're taking away that choice by making these presumptions. And I think that's actually just, it's a very fine line, and we have to make sure that we're providing those individuals with that choice and not actually taking away some of those rights. So if you could just clarify that a little.
Yeah, I'll make 2 points in response to that. I think, the bill as presented right now does involve choice. It does allow a person to decline to have an attorney. But I think without this bill, there already is a presumption. The presumption is that the person does not need or want an attorney, and that they have to opt into that. They have to specifically, the onus is on the person to say, I would like an attorney, I want to contest the guardianship, I've got questions. And so already is a presumption absent this bill. So I think what this bill is creating a presumption that I think is a bit more protective of people's rights, frankly. The presumption is that they do want an attorney, and then they have the option to opt out of the attorney, of having an attorney. So the bill still creates choice, it just flips the presumption as it already exists.
Thank you very much for the information. Thank you for the question, Representative Poirier. Committee members, are there any additional questions for Lauren Willie? I am not seeing any, so I will send you back to the attendee part of the meeting. We appreciate you being here. And committee members, I will need to leave in just a moment to attend a work session in health coverage, insurance, and financial services. I think that Representative Harnett has had to step away as well. And so Representative Babbage, are you able to resume your chairing duties that you performed so well this morning?
I am available, although I have to admit my expertise on this particular subject concerns me a bit, but certainly I can preside.
Okay, I apologize, everyone. It's very hard to predict when bills will come up for work sessions in other committees. So I'm going to step away in just a moment. Representative Reckitt, your hand's up, go ahead. We're not able to hear you, Representative.
I wanted to, if it's appropriate, ask a question of Representative Poirier, because it sounded to me, is that possible?
It is. I am going to pass the virtual gavel over to Representative Babbage and then let you ask the question because I am due back at HCIFS. Okay.
Yeah.
Go ahead. And Chris, Representative Babbage, thank you so much. Committee members, I'll see you in a little bit.
Thank you. Representative Reckitt, did you have a question?
Yes, for Representative Poirier, if she's willing to speculate on my question. And it may or you may or may not know the answer. I'm just guessing really that from your acknowledgement that you've worked with people with disabilities of one sort or another, that you might have information as to whether or not either of the way that this presumption could swing either exists or could swing would be good or bad for the people that you have had interactions with around this kind of issue, if not this particular one.
Thank you for the question, Representative Reckitt. I can only speak to the people that I've interacted with in my line of work. And I've had several that have had guardianship cases go through in my working with them. I haven't had direct contact with the courts in that, but I know the process they've gone through. And in each of those cases, it's been the advocate that has helped them decide whether or not they needed to have guardianship. And it's worked out fine, the process that in place now. I think based on what I'm aware of and the cases that I've seen, it's far and few between that there are cases that I guess you could say that guardian is taking advantage of the situation. Does it happen? Probably. But I don't think it's to the extent that it's a huge issue to change a whole process. The advocates in the probate courts seem to really keen in and not just see a person once, it's several times. And they establish the need. So I have a hard time seeing that this is necessary. And then the whole matter of payment is also very concerning, because just because a person has some financial means doesn't mean that they understand those means. So to say that they have to pay for it, they might not understand what they're having to pay. So that's a whole other can of worms to think about too.
Thank you. That's very helpful. I appreciate it.
Thank you. We have nobody before us at this time. Are there any other questions for the analyst regarding LD 480? What is the will of the committee?
There's two hands up. Chris, can you see them?
I thank you for that. I was not seeing them. Representative Newell?
Yes, thank you, Mr. Chair.
Yes.
Acting Mr. Chair, thank you for recognizing me. Just following that conversation between Representative Reckett and Representative Poirier, can we be reminded, or can I be reminded about the process in the assignment, if I can say that, of an advocate?
May I clarify if when you were speaking of an advocate, Representative Poirier, you were speaking of the court-appointed visitor? Okay, then in every case that's brought, the court does appoint a visitor to visit the person who would be the subject of the petition to explain what the petition is about, interview the person, and then report back to the court. The statute lays it all out. I'm going to call it up on my computer so that I'm not lying to you. Just want to make sure. Okay, I can share that statute with you if you want. So whenever there is a petition, and this is under the guardianship, but there's similar laws for conservatorship, the court has to appoint a visitor. The visitor interviews the respondent. The respondent is the word that the probate code uses for the person who's the subject of the petition who might have a guardian appointed. They explain the nature and purpose and effect of the petition and what that would, the powers that the guardian might have. They try and ascertain the respondent's views about this proposed guardianship. They inform the respondent of their right to employ and consult with an attorney at their own expense or request that a court appoint one. And they explain that the fees might be paid from the respondent's assets. The court can also direct that the visitor in a particular case perform additional duties. So viewing the residence and figuring out sort of maybe the suitability of that residence, obtaining medical information about the respondent, and then if there's any specific allegations in the petition, investigating those as well. And then that visitor reports back to the probate court and has to give information on a whole slew of different items, including, for example, whether the respondent has asked for an attorney, or whether the visitor recommends, then an attorney be appointed. But there's a whole bunch of statutory requirements that they also have to report back. And then there are similar statutes, like you said, for the conservatorship and the other protective arrangements.
Thank you for that, Janet. Are there any other questions of the committee of Ms. Stocco before we? Representative Evangelos, do you have a question?
I had an inquiry. I wanted to ask you a question. Are we allowed to vote without a chair?
The interim chair does serve as a chair.
Okay.
So legally, yes, we are.
Okay.
I'll remind the committee, though, that we do have the right to reconsider if there's ever a bit of information that we don't think we have at the time and wish to do that. Of course, you have to, it's the will of the committee on whether to accept reconsideration or not, but yes.
I would
Janet?
just point out you need a senator.
Yeah.
Oh, you need a senator to vote. Yes.
Yeah.
That's correct.
Well, if there's no further work to be done on this one today, and I'm not cutting anybody off, but if there isn't, I'll make a motion to table.
There's no discussion on a motion to table. Actually, we have been calling the roll on that recently. So, Supi, if you don't mind, would you call the roll?
Mr. Chair, I don't mind at all. However, that's a vote. So didn't we just say we can't vote without a senator?
Uh-huh.
Or
So
do we
we-
have to have permission from the president of the Senate?
You'd have to give me a few minutes to send an email. There's a process that has to be followed in order to, I mean, you could just not do anything. I look to Janet for that one, but I don't think you have to, I don't think you have to table. You can just move on to the next bill.
Set it aside, as it were.
Yes. Well, this may be the difference between formally tabling and putting the motion, putting the business away indefinitely, which is what a table is, or tabling in order to revisit, which sometimes we just did with a show of hands in past committees. But then I'll make an executive decision, and without a senator, we can't make a decision on the matter anyway. So at this time, we'll move on to the next work session, and providing time at the end of today's business, we can revisit if it's the will of the committee. Does that sound okay to the committee members? If that is the case, is LD 840 the next one that was on the order that we had agreed upon?
I think the order that was listed was LD 1804 next.
Yes.
Okay. Okay, then I will open the work session on LD 1804. And yes, Representative Thorne.
Thank you, Mr. Chair. I'm just curious what the point of having the work session if we're unable to make a vote after.
We anticipate being able to make a vote very shortly.
Okay.
Normally, we would sometimes recess until a senator shows up in order for that vote to happen informally. But I don't know if recess is even the right word. But we can still transact business and get a better understanding of what's before us if the committee wishes to do so. And with that, Peggy, would you remind us where we are with 1804?
Or I would be happy to. So this is actually your second work session on LD 1804. It is an act to provide consistency in the laws regarding domestic partners. You had walked through the bill, and there were some questions raised about especially in certain situations, so the purpose of the bill is to use one definition for domestic partner. And that would be added into Title I in the general words and phrases section. And rather than having various definitions throughout the statutes, anytime the term domestic partner was used, you would apply that definition. It's not the same as a registered domestic partner. That is a very specific category of people who have gone through the registration process that's established and is administered by the Department of Health and Human Services and their Data, Research, and Vital Statistics Office. And that's something people can do online to have that kind of official registration. So that's one category of domestic partners. The bigger category of domestic, so that's registered domestic partners. The bigger category of domestic partners would include registered domestic partners, but it would also include people who meet that definition but haven't gone through that registration process. I think there were some questions raised in particular by hospitals that have to deal with a couple of situations. One is when one of the domestic partners has passed away in the hospital. And so there's a question of who controls what happens with that deceased person's body. And the hospitals were concerned that if you didn't have that specific definition about having to have a relationship that it lasted at least a year, that would create confusion for whoever had to administer that in hospitals or other healthcare settings. So there's nothing to stop an entity that has to administer this to asking for the information necessary, the evidence necessary to show that such a relationship exists. But Representative Roberts, the sponsor of the bill, had put together an amendment that, and I will share that if you would like. And I think I did send that out. Actually, I sent it out twice because we needed to amend it. Come on, open. And that's not the one I want. To address that question, to give a little more information about what evidence a hospital or somebody else could look to. And so I'll share my screen right now. So this is section 20 of the bill dealing with possession or acts or dealing with a deceased body. And so the bill originally said a domestic partner and then crossed everything else out. So what this amendment does is it says, for the purposes of this section, domestic partner means a registered domestic partner. So if you've got the registration, you're set. You just show that and everybody's fine. Or one of two unmarried adults who are domiciled together under long-term arrangements that evidence a commitment to remain responsible indefinitely for each other's welfare. So that's the definition in Title I. The bill puts it in Title I. Including evidence of an emotional, physical, and financial relationship with the decedent, similar to that of a spouse. So this last language here comes from the Healthcare Decisions Act, which is in Title 18C, and it is in the hierarchy of who can act as a surrogate in making healthcare decisions when the person is incapable of making them themselves. The healthcare provider looks at this hierarchy, and this language is there. It doesn't say domestic partner in the Healthcare Decisions Act. It says a person who has an emotional, physical, and financial relationship with the decedent, well, to the patient, similar to that of a spouse. So the hospitals are comfortable using that language with regard to healthcare decisions when you have a patient who's still alive, but cannot make his or her own decisions. And so they look at somebody else, and the patient hasn't executed a healthcare power of attorney or hasn't designated an agent in writing. So the hospital has to figure out who to listen to. So this is the language they have right now with regard to healthcare decisions. So we're incorporating that language into who the healthcare provider listens to when the patient has actually died. So you have a decedent who gets to go forward with taking care of the remains of that person. So it kind of deviates from the purpose of the bill, which was to just use the term domestic partner and say, every time you see that, go back and look at Title I because that's defined. But there was such concern on the parts of the hospitals that they wouldn't know what to do, and it would slow everything down and cause problems. So I think this was meant to help out those situations. I will say that I have some information from Jeff Austin that he said he doesn't oppose this. He appreciates this. Jeff Austin works for the Maine Hospital Association, but they might still be looking for some additional information. And maybe what will happen is advocacy groups may provide some sort of implementation pathways that say, here's the information you can look for in order to go forward with this. So this is the first part of the amendment in Representative Roberts' amendment. And I don't believe she was going to be able to be here today. And then this is in the Uniform Anatomical Gift Act, which right now gives the registered domestic partner a say in the hierarchy of who can make an anatomical gift when there is a decedent. And so this is paragraph C, so it's at least the third person down. So right now it says the registered domestic partner. The bill changed it to just domestic partner. This again is responding to the concerns that hospitals in particular need an answer very quickly when you're dealing with anatomical gifts. And so we're again incorporating that same language that we just did in section 20. So that's what I have for proposed amendments to LD 1804. And I'm not sure if there were other questions, but I'm certainly happy to try to answer them.
Thank you, Peggy. That's excellent. And I'm appreciative that language actually was in 18C. That explains a lot to me. Are there questions for the analyst? Yes, Representative Sheehan.
Thanks, Mr. Chair, and thank you, Peggy, for that helpful bill analysis. I just wanted to clarify if you're saying that the hospitals are satisfied with the language in the amendment.
So I hope this is okay to read Jeff's email. We just want the committee to be clear that while the statutes may be consistent and clean, there is value in that. The implementation of this language by regulated entities may be inconsistent. So we don't oppose the language and we don't oppose the direction you are headed, but we do want the committee to know that they are giving us a GUI definition that may be applied differently from institution to institution. I would say that's not as GUI a definition as I think he thinks we started with in the bill. But I think he also is saying that the hospitals would benefit if there were some additional information not provided in statute necessarily, but provided by people who recognize domestic partnerships. What's the best way to inquire of somebody who claims to be a domestic partner to show that, yes, indeed, they meet that definition. So there might be a standard set of questions to make sure that they really do have an emotional, physical, and financial relationship with the decedent.
Got it. And would that be something that's not necessarily something that has to be in statute, or?
I don't think that needs to be in statute. This says including evidence of this type of relationship. So
Right. So they could follow, for example, you know, the insurance code, which allows insurers to require proof like both partners' names on a mortgage or other things like that.
Right.
Okay.
Right. So it's evidence. You're looking for evidence, and if there are entities that want to provide information that is helpful to determine what that evidence is, that's great. Mortgage, you know, power bills, whatever. Yeah.
Sweet.
Go ahead,
Mr. Chair,
Representative
can I ask one more question? Because
Absolutely.
I had in my notes questions that were, I think, still pending about the paid family medical leave program. And I had followed up with Senator Daughtry, who chaired the commission. And while they haven't reported out a bill yet, my understanding was that the will of the commission was to follow the main definition of domestic partners, so that whatever changes may flow out of this bill wouldn't actually create any conflicts between the main definition and the federal definition. Does that make
Is that
sense?
a question for Peggy?
It was just, it did, I was wondering if it made sense to Peggy, you know, from her perspective. Does that answer the question that came up about potential conflicts between the two definitions?
Right. So my understanding, so the question that came up at the public hearing, I believe, was that there is a study, an actuarial assessment that is recommended to go forward about paid family leave. And it's important to identify who's going to be included in that actuarial assessment. My understanding was that they might be relying on the federal definition as opposed to whatever is in the state law. So it doesn't, so I'm not sure if we got the same information and we're interpreting it differently. So I think it won't, whatever you do here is not going to affect how that study goes forward. And it actually hasn't started yet. That piece of the study. So there is an existing family, a paid family leave study that's about to submit its report. And one of its recommendations is for there to be an actuarial study going forward about what the cost would be for paid family leave. And that would include domestic partners. But my understanding was they would be using the federal definition of domestic partners.
Does that answer the question, Representative Sheehan? You're welcome to go on if you have more.
Yeah, I'm still a little bit unclear, but I was wondering if Mary Benato might be better positioned to answer that question. I don't know if she's...
Hey, while Mary's coming in, Ms. Benato is coming in, Peggy, you commented about some groups with interest might be able to elaborate on how to go forward. Did you mean informally or did you mean legislatively, revisions?
I think it's actually was Jeff Austin's suggestion, and I think he means informally, that you wouldn't amend the law, you wouldn't direct anybody to provide that information, but the people that this this law would be affecting would be able to provide guidance. If you want to look at what's evidence of an emotional, physical, and financial relationship similar to that of a spouse, here are some of the things that you can look at quickly in order to make that decision and recognize that this person can make decisions.
Thank you for that. Welcome, Ms. Bernardo. Good to see you again. Representative Sheehan, would you like to continue?
Thanks, Mr. Chair. You may have heard the conversation. We've sort of been trying to get clarity on, I think, two related issues. One being the sort of the new language in the amendment and how it relates to the hospital's concerns, and also the question of the definition as regards the development of the paid family and medical leave benefits program.
And I want to make sure that I disclose some additional conversations that we've had with Peter Gore on the phone and also by email, if that's okay. Okay. With respect to the FMLA definition, and which will be the operative definition for the federal one or the one that exists in Title 26 right now, I have no information and no idea which it's going to be. So just want to say that. Nothing to offer there. And then with respect to Mr. Austin, a few things. That was a situation. This bill is about trying to get some uniformity and decluttering the statutes and having consistency. However, when it comes in this particular instance, what we came to understand is that the hospitals are looking for a decision maker. This is not their employee. They do not know these families. And they have a situation where they have to take care of a deceased body, or they have, decide who's going to make a decision about an anatomical gift. And they don't know these people. So that's a situation where you're looking for a decision maker. And so we actually suggested you put it sliding over the language from the Healthcare Decisions Act into these other two areas only for this purpose. He then also recommended, as a matter of simplicity, that we go with the domestic partner definition, because if people have it, then at least that's done. You don't need to make any further inquiries at this already very stressful time. We actually asked about whether there was any sort of standardization in the industry about educating hospitals about how to implement these things. So, it is certainly an interest that many people have, and I assume it's one that's shared by the hospitals to make sure that the right people are making these decisions. So that's all I can really say right now. Although I do have things to say about FMLA that are not what you asked.
Thank you. That was helpful.
Ms. Bernardo, thank you, Representative Sheehan, for that line of questioning. If not that you're the one to ask for this necessarily, but since you're in front of us, the language that you have borrowed from 18C regarding surrogate decision making, has that been tested? I was wondering about the Hospital Association's experience with that, or if we're in still a interim mode here. Thank you.
Yeah, sure. And Mr. Austin may be on the phone, and then he can speak for whatever, he can speak for himself. But we asked, and he said that he thought that all of the hospitals had some experience with that definition. They'd all confronted this issue. That some, of course, would have had more experience and others less, but that it was something that they all had some familiarity with. And again, drawing from my own experience too, with a horrible situation that I experienced with a friend, trying to get to a decision quickly, and hopefully a good one. We were open to saying, fine, if this is working and hospitals understand this, it can work with this, then it's really important to do that to spare everyone the sort of ongoing misery that can also come from a wrong decision.
Thank you. While we have Ms. Bernardo in front of us, are there questions for Ms. Bernardo from the committee? Representative Newell, that's it. You may go ahead, Representative Newell, go ahead.
Just want to follow along Representative Sheenan's questioning to Ms. Bernardo. Thank you for being here, and thank you for allowing me to pose my question. as indicated by Peggy, this is kind of steered away from the original intent of the bill language by proposing this amendment. So my question is, what is the current standard of practice coming from hospitals in, as you mentioned in your example, trying to identify a decision maker? Where then would that put the recognition of families, let's say an eldest child?
So with respect to the existing statutes, I'm just trying to find them quickly here. But the bill strikes the existing definition of domestic partner for anatomical gifts and disposition of deceased bodies. And absent this amendment would have gone with the probate code definition, which, as you know from my saying this before, it's broad and intended to help you as the entity administering it decide what is important to you in making sure that this is the kind of family relationship that's described. So it doesn't change anything with respect to order of priority. So to the extent that a domestic partner would have had priority over an adult child, for example, that will remain. So it doesn't change any of that. This is all solely about how do we ascertain who is a domestic partner. In this particular instance, this is, in contrast to what Mr. Gore has requested with respect to FMLA and employers, this was one that, it's your decision, of course, and I respect that, but this is one that seemed to us as a matter of compassion and really exigent circumstances to allow some variation from the goal of uniformity. And I will note that there are just a few examples of times in the probate code still where the term registered domestic partnership is used. So for example, with respect to who has priority as a potential person representative of an estate, who can take a spousal share in an estate. There's just a few examples. So it's very rare. And it is, of course, this committee's decision, but it was an amendment that those of us working on this were willing to support. In contrast, again, to the employment area, which I hope I will be permitted the privilege to be able to explain that.
Thank you for that line of questioning. My understanding is that current law prioritizes spouse and an established domestic partner, then adult children, then parent, then siblings. Thank you.
Sorry, I didn't clarify that. Yeah.
Thank you. Are there other questions from Ms. Bernardo? Representative Sheehan.
I just wanted to better understand what issue you wanted to address with regard to the paid family medical and leave benefits program, because I did have further questions about it. I just wasn't clear what your take on it was.
Well, it's just to be in the interest of full disclosure. Mr. Gore spoke neither for nor against the bill at the public hearing, and then later submitted some written testimony. We spoke with him on the 31st, which was a Monday. He got back to us after talking to some stakeholders by Wednesday, saying they would like to add a registry definition, which FMLA does not include the registry definition now. It uses the insurance definition. And he was going to be away until Monday. So I did email him yesterday and say, I guess this is in contrast to hospitals, right? Employers are the decision makers, unless there's a statutorily prescribed benefit. Employers are the decision makers, so they can set the terms for their benefits. And with insurance, you already have a determination of domestic partnership, which is one benefit that comes to at least to some people through their jobs. So I think our question was, we already have, employers can decide and ask for more information or set criteria, as is appropriate. They are the decision makers, and therefore, in contrast to hospitals that really needed something additional, they don't know these people, employers were really not in the same boat. I also just wanted to say, and I understand, I do have sympathy to the concerns about administrability in general for everything. But having said that, with FMLA, you're talking about he had been concerned, and he said this, I think, at the public hearing, you could have two people on a lease for a year, and does that make them domestic partners? And the answer to that is like, no, you get to decide, right, what your criteria are. And with FMLA in particular, and again, we don't even have paid family medical leave. Like right now, it is unpaid. An employee has to provide notice. There can be medical verification. Sometimes it's for a death. It doesn't seem to me like it's something that's brimming with opportunities for fraud and misuse. Again, I'm not the employer, so it's not for me to say, but it just, there really are ways for employers to ascertain whether the employee really has this relationship and they want to extend this benefit to them. They have control over their benefits, except to the extent that they're statutorily prescribed. So we didn't have that same concern, and therefore did not believe this was an example where we should depart from the effort of standardization that's reflected by this bill.
Thank you.
Thank you, Ms. Bernardo. Are there other questions for Ms. Bernardo? Well, thank you very much. I appreciate your rescuing us on information such as you've given. And at this time, I am delighted to return the gavel to our esteemed Senate Chair, now that I see her back with us. So thank you, Senator Carney.
Thank you so much, Representative Babbage, and my apologies, everybody, for having to step away for another work session. I'm happy to be back, and I see that Representative Moriarty has his hand raised. Go ahead, Representative.
Thank you, Madam Chair. I hope that what I'm about to say will make some sense, your having been away for the past half hour or so. I have one observation and then one question for Peggy. First of all, my takeaway from Jeff Austin's letter is that, yes, the amendment is fine, but be on notice that various institutions may interpret it differently. I accept that, and I think that's almost inevitable with much of what we pass or recommend for passage. So I don't think that reservation is grounds to table and schedule yet another work session. My question for Peggy, in light of the fact that the sponsor is not here, is this. If we were to make the underlying definition in section 1, which is right at the top of the bill as printed, a little less gooey, because some people have, I guess Jeff was sort of concerned about that. What if we said domestic partner means a registered domestic partner or one of two unmarried adults and so forth and so on. If we inserted the registered domestic partnership option as one of two alternatives to satisfy the definition, do you think that makes it clearer if it's universally applied and worked into the all of the main revised statutes?
I don't know if it's clearer. I mean, I think the reason it was some of the people in support of the bill have agreed to include it in those definitions of who can take custody of the remains or in the Anatomical Gift Act is because you need a decision right away. And that is evidence that these two people are domestic partners because they're already registered. That's, a paper in hand. And you don't always need that decision quite as quickly. So maybe that's more or less a policy decision for you to decide if you want to bring in registered domestic partner in the definition of domestic partner.
Well, I'll follow quickly. Currently, are registered domestic partners, or do they qualify as domestic partners across the board throughout the entire volume of statutes?
Yes.
So there's no harm, it seems to me, in referencing that in the section 1 definition, if that's the reality anyway.
Right. I mean, I think that's a decision for the committee to make, and
Okay, good. Thank you.
I'm
Yep.
not elected. Thank goodness.
No. And you're not the sponsor. So thank you.
Representative Babbage, go ahead. Do you have discussion or a question for someone?
I have a question just for my own clarification. Representative Moriarty's question made me want to confirm this because the amendment that I'm working with is the sponsored Representative Roberts amendment from last Friday. But when Peggy screen shared, it was my understanding that registered domestic partner has been added in both places. Is that right? 1A and C?
Yes, and that's actually a revised amendment that I
Yes.
sent yesterday.
But it is already there in the now current amendment that's being before us. That's just
It's in Representative Roberts' amendment in 2 places only.
Yeah,
got you. I see.
Right. The rest of the bill just refers to domestic partner in sections 20 and 24. The recommendation in the amendment is to expand the definition of domestic partner to include more kind of evidence of what makes what qualifies as a domestic partner, so people can make decisions right away on dealing in those situations.
Right. I've got that. In other words, we have, as I look at, well, do I have the bill 1804? Okay. So when we talk about domestic partner, yeah, there's several references all through the bill, but here we're specifying registered domestic partner and or is that and or two unmarried adults that have this evidentiary relationship based on, for instance, what the new one being emotional, physical, and financial. Correct?
Right. So what the amendment doing is saying, here's evidence you can use to show that these people meet the definition of domestic partner in these circumstances.
Thank you. Got it. Appreciate it. Thank you, Madam Chair.
You're welcome. I've kind of jumped in the middle of this conversation. I know that there are a couple of folks in the attendee space who have their hands raised. And Representative Reckett, did you have a question for Peggy or committee discussion or a question for someone else? We're not able to hear you.
No, I was prepared to make a motion, but if there's other people that need to talk, that's fine.
I think it would be helpful actually to have a motion to kind of frame the continuation of our discussion. Go ahead.
All right, I want to move to pass, ought to pass as amended by the latest amendment that came out today.
Thank you. And seconded by Representative Sheehan. Thank you. And now we'll move into committee discussion. I did because I'm sort of new to the discussion, and I see that Peter Gore's hand is raised in the attendee space. Has he spoken to the committee yet in the work session? Okay, I'm going to bring him over to the panel because I would like to give him an opportunity to speak, and then we will resume our committee discussion. So give me one moment.
I think Representative Reckett should take her hand down.
I didn't tell you which hand. I've got 2 that aren't yellow, but
Peter Gore, welcome to the Judiciary Committee. And could you, before you begin to speak on your substantive issue, can you just let us know what you wish to address?
I would just like to address some of the issues around the remaining issues or the issues that remain with the bill and FMLA from our perspective and eligibility. If you look at Title 26, 483 now, there's a very clear 7-point definition of what a domestic partner is for employers to look at and determine eligibility. And, you know, to Mr. Austin's point, and to my original testimony, the definition that's being proposed is, I wouldn't use the word gooey, I would probably use something different, but it will present challenges for businesses, because I'm not sure, despite Ms. Bonato's discussion, we had a good discussion that I don't know how employers ask for, there's nothing in that definition that allows them to ask for proof. And what are they asking proof of when someone asks for FMLA leave, whether it's paid or unpaid? And as I said, and Mr. Austin has said the same thing, you know, this presents or opens the door for inconsistency in the application of the definition in the workplace. Remember, most businesses in the state don't have HR professionals. They're small businesses. So the business owners trying to figure this out for themselves. And when there are issues that involve eligibility and denial of FMLA, that can result in litigation, which a small business can ill afford. So what I said to Ms. Bonato, and I would say to you this afternoon, is all employers are asking for is a way to get proof of the relationship. My original suggestion was, you know, throw out the domicile for 12 months and just say they have to be on the registry. You know, quite frankly, Representative Moriarty's suggestion to add that or registry to the original definition, or create the definition, the amended definition as the overall definition of domestic partners, not a bad idea, because there is some yardstick by which to judge the relationship. But again, if you look at 843 now in 26, there is 7 points that allows an employer to look at for proof of domestic partnership when it comes to eligibility of FMLA. And that's all we're asking for. Give us a way to ask, you know, individuals who are asserting a domestic partnership proof.
Thank you very much for sharing your thoughts. Committee members, are there questions for Peter Gore? Representative Moriarty, go ahead.
Thank you, Madam Chair. Good afternoon, Mr. Gore. I just need to get on track with the FMLA thing. I understand that there is a study underway. Is it anticipated that there will be a bill for this session as a result of that study?
No. The chair and the two chairs of the committee have submitted a resolve to extend the reporting period for the commission until November of this year, I believe, so they can get their actuarial study done, or at least in the pipeline. So you will not see a bill in this session for the issue. But FMLA is complicated in Maine because we have a state and we have a federal statute, and different employers operate under different FMLA statutes. Those basically under 50 employees move to the state statute. Employers with 50 or more have to comply with a federal statute. And sometimes they're interchangeable. So it's not as simple as it looks. And FMLA in Maine applies to a business with 15 or more employees, whereas in most places in the country, it's either 50 or 25.
Well, do you expect as a result of the report of the study that there will be a recommended definition of domestic partner?
No, I don't actually. I don't think that's within their purview. I mean, I guess it could be. I shouldn't say that. I shouldn't be so quick to say that. It could be. I mean, they are charged with looking at the entire act, and eligibility and who would qualify is potentially part of that.
Thank you.
And Peter Gore, I have a question for you related to Representative Moriarty's. Has the actual actuarial study actually started at this point?
No, Senator, not to my knowledge. They are in the process of gathering bids and putting together an RFP, I think, to hire.
Okay, thank you. That's great. Thank you. That's helpful. So it is not even out to bid at this point, but they're preparing to put it out to bid.
At the last meeting, I believe that's where that things were left.
Thank you. That's really helpful. All right, committee members, any other questions for Peter Gore? Okay, I'm going to send you back with
Thank you.
thanks to the attendee part of the meeting. And committee members, this is a little irregular, but I would like to take a recess so that I can catch up to where all of you are, because I walked in the middle of the conversation and I just need a little bit of time. And so it is 2:22 now. Is everybody okay if we take a break until 2:30? And it'll just give me a chance to shift gears from HCIFS to judiciary. All right. Thank you, everybody. We'll see you back at 2:30.
Okay. Hey, Ann,
Yes.
Chris and I ended up in a different place all by ourselves. We used the caucus link from this morning, but we were alone.
Yeah, I don't know that anybody else was like, I wasn't understanding that there was going to be a caucus, so I didn't
Yeah, we didn't,
follow that link.
yeah, I didn't either. I thought we'd just taken a break.
Yeah, I just needed to catch up to where all of you were, and so.
Oh, okay, I see. All right, so we
Yeah.
didn't miss a caucus. Okay.
No. Committee members, if you're able to activate your video so that we can resume our meeting, I'd appreciate it. All right, thank you everyone for returning to the meeting. And at this point, I guess what I'd like to do is we can continue our committee discussion. At some point, I would like to make a motion to table this bill because I guess I have concerns that, you know, having been a practitioner and represented both employees and employers in Family Medical Leave Act cases, I want to take a little bit of a deeper dive, and I didn't have a chance to do that before today's work session, into how this proposal lines up with those two statutes, both the federal and the state family medical leave. I don't want us to kind of inadvertently make it harder for people to get family medical leave. And so I just feel that we, you know, there needs to be, at least for me to be able to cast my vote, I would like the opportunity to take more time to look at this. Representative Reckett, your hand is up.
Yes, I'm concerned because I didn't think this bill had anything at all to do with family medical leave. But we went off in that angle because of the consistency issue. And I thought that section 20 had to do with decision-making in a hospital, and 24 had to do with dealing with people who've already died. So if this family medical leave is in here somewhere, I never spotted it. I only just heard the peripheral discussion, so I could be dead wrong. So
yeah, I can clarify that. So the amendment that we have before us just changes 2 sections in the original bill.
Mm-hmm.
And so everything else that was in the original bill remains part of the bill that we would cast a vote on. And that does include provisions related to the main family medical leave.
Yeah, that's
and
helpful.
then separately, I'm also just concerned about the impact on the federal family leave, because employers with 50 or more employees and employees in businesses with 50 or more employees, they have 2 sets of rights, one under the federal law and one under the state law. And I just, in my own mind, really need to understand how all of that works. And I don't right now. So that's where the Family Medical Leave Act issue comes in, Representative Reckett.
Thank you.
Yeah. Okay. Representative Evangelos?
Madam Chair, if we're going to be coming back to another work session on this, you know, it'll be a lot fresher in our minds on that day than it is if we continue to go today. I don't want to cut off discussion. And if somebody raises their hand when I do it, Rick, I'll take it back, but I'll move to table.
Thank you very much, Representative Evangelos. We have a motion to table. Is there a second? Seconded by Representative Sheehan. Thank you both very much. And then on the motion to table, what I'd like to do is for us to use our actual physical hands. Raise your hand if you are supportive of the motion to table, please. And then our clerk will record the vote. It looks like And Representative Libby, did you wish to vote on this as well? It appears that she is not in attendance at this point.
I'm counting 10.
Yes, thank you very much. Okay, so this LD 1804 is tabled, and let's quickly go back to LD. Actually, let's not go back to 480, but let's move on to LD 8. Okay, so we've closed the session on 1804. We'll now open the work session on LD 840, getting all my 4s and 8s mixed up, on LD 840, which is an act to prevent power line electrocutions. And we'll ask Peggy to please provide the bill analysis, and I will also bring the bill sponsor over.
Okay, great. So this is an act to prevent power line electrocutions. It amends the indemnification section of the Overhead High Voltage Line Safety Act. The current law says that if, so the Overhead High Voltage Line Safety Act establishes very strict safety precautions dealing with anybody working around using any kind of equipment around high voltage power lines. If anybody violates those safety precautions and it results in somebody coming or something coming in contact with the line and causing any kind of personal injuries or property damages, then whoever allowed that person to come in contact with that line is actually liable for all damages. So if you remember the case, the employee had a mast run into a power line that the evidence was that it was lower than it was supposed to be, caused physical damages, caused property damages. The injured employee sued CMP. CMP ended up with having to be responsible for those damages, but then CMP sued the employers, the employer of the person who was injured, and the law court said the statute totally indemnified CMP because the employer violated those safety requirements that are in the statute. So the statute currently says the owner of the power line is indemnified. It doesn't mean they're immune. It means they're indemnified if somebody else is responsible for breaking those requirements. What the bill does and what Representative Berry proposed in the amendment is to do away with that indemnification and instead share liability if the owner of that power line is actually responsible through some sort of negligence or other non-compliance with other things that apply to the power line owner. So the Overhead High Voltage Safety Line Act really applies to everybody but the power line owner. And this would say there's not indemnification if there is some liability, if there's some negligence on the part of the power line owner. Representative Berry has language in his amendment that also says the employer shouldn't be doubly liable if there's insurance through workers' compensation. Then they wouldn't be liable under the Safety Act and workers' compensation.
Thank you very much. Peggy, I would like, and committee members, if you don't mind me jumping in, I had a couple of questions about the amendment that Representative Berry has proposed. Can you help us understand how that amendment would apply in a situation where everybody was a little bit at fault? So the injured party was somewhat at fault, the employer was somewhat at fault, and the power company was also somewhat at fault. You could assume a third each, but I guess my underlying concern is, I think in amending the statute, we need to make sure that we're not somehow depriving the person who was electrocuted of a right to recovery in some fashion.
Right. So, you know, I know there's an attorney in the attendees who can probably address this much more succinctly than I can. What the amendment does is it applies the comparative negligence statute, which allows the court or the jury to look at everybody that's involved and determine what the fault, the contributory fault of each person was. So if the it allows the jury to look at the total amount of damages and then attribute fault to each party, and it would allow recovery, I think, unless there's if the person who's injured, I'm trying to remember exactly how it applies, and I believe Attorney Mills would probably be able to address this faster than I would.
Should I call him in, Peggy?
Yeah, because I'm not sure if the employee were more than 50% liable, how that affects the under a comparative negligence statute. But also, if the way workers' compensation applies, and maybe Representative Moriarty knows more about this, I'm not sure that under workers' compensation, the employee doesn't have a right of action against the employer. And so that just kind of gets a little more complicated to figure out those pieces. If you didn't have that relationship, then comparative negligence would be a much easier thing to apply, but you also have to deal with that additional complication of workers' compensation.
Okay, yeah, and I think maybe we can ask Attorney Mills, who has joined us, a couple of different factual scenarios with and without the workers' comp element. And I see Representative Barry, your hand is up. Can you just let us know the purpose for raising your hand?
Sure. I honestly was just thinking I'd buy some time for Ms. Barry Mills. He's here, and I think he's better qualified to answer, so I'll defer.
Okay, thank you. And thank you, Barry Mills, for joining us today. We really appreciate you being here. So did you understand, I guess we're probably going to run a couple of different questions by you, but did you hear the first scenario, or would you like me to repeat it?
I think I understand the question. The question is, to what extent does this law take into account the responsibility of the injured employee?
Yes.
And here is where we apply the standard comparative negligence test. If a jury or the trier of fact finds that the injured person was 50% or more at fault, there is no recovery. The injured person gets nothing. If the injured person is 49% at fault, then damages that would be awarded to the injured person is reduced by 49%. And the person would only recover 51% of the damages to which be entitled.
Okay, and can you take us through the analysis of the proposed amendment in a different factual scenario, actually two different factual scenarios, one in which there is an employer involved, so much like the case that gave rise to the legislation, and then another one where perhaps rather than an employee being injured, a member of the public who was using the boatyard was injured, and each party was 1/3% responsible for the accident occurring.
For the case, then the responsibility would be 1/3, 1/3, 1/3, and the injured, whatever damages were awarded, those damages would be reduced by 1/3, respecting the injured employees, the injured person's own responsibility. Whether that person is an employee or not is irrelevant so far as the person who's injured. The status comes into play when we're talking, when we are considering an employer's liability, an employer who has arranged for workers' compensation as they supposed to do under the law. The existing statute is a bit of an anomaly in that I can't think of any other situation in Maine law, there may be, but I can't think of any, in which an employer becomes liable for the employee's injury based upon a negligence theory. It's a general principle that the employer is immune from liability because of negligence, because of our workers' compensation law. That's why workers' comp was put in. You don't have to prove negligence. The immunity is across the board in every other instance. Then there's a policy consideration. Why shouldn't the employer be immune in the situation involving overhead power lines? To me, it is no different than an employer who has driven a car too fast, perhaps, and a passenger is injured. The employer would be immune from liability because of workers' compensation. If that's the case there, why isn't it the case here? And if you are going to repeal employers' liability, or if you are going to repeal employers' immunity, rather, in this instance, in what other instances are you going to do that? And what kind of chipping away is no, LD 840 merely creates a situation where the traditional principles of tort law apply. Those situations that govern every other similar instances that would occur here in the state of Maine, where because of the negligence of employer plus another person.
Okay, thank you. I see that there are some committee members with their hands up. I'm sure they have questions for you. I appreciate you answering mine. And Representative Evangelos, you're next.
Hi, Mr. Mills. Mr. Mills, I just want to make sure I understand how the math will work. So if I'm the injured party and I'm 25% responsible, is it then 25% that factors in and not the 49%?
That's true. Your recovery would be reduced by 25%. If you are 50%, then you get nothing.
Thank you.
Thank you for the question. Representative Moriarty, go ahead with your question. We're not able to hear you, Representative.
Oh, that happened. Sorry. Two questions for Attorney Mills. As I read the comparative negligence statute, damages are not awarded or determined by percentage, but rather to the extent that a jury determines the just and equitable contribution of the two
That's
parties.
true. I stand corrected on that.
Okay.
We tend to think in terms of percentages.
I know.
But the language is different. And,
okay, fair enough. My second question is, I wonder whether you were involved in Brian Smith's third-party action against CMP.
Yes, I represented the boatyard on that.
Okay. Do you know, because this is not clear from the law court opinion, whether the comparative negligence statute was applied in that civil action?
No, it was not. Bear in mind that case came to the law court not on the merits, but on a motion for attachment.
That's right. I'm sorry. Strike my question. You're right. Yep. My question was not correct.
Yeah, but in applying that motion for, in applying the law on that motion for attachment, it made clear that I think that comparative negligence would not apply.
Yeah, under the existing law, it would not apply. Okay. Representative Babbage, go ahead with your question.
Thank you very much, Madam Chair. Mr. Mills, to clarify, in the original case, not the law court case that you were involved with, what was the threshold that Central Maine Power had to meet in order to get a judgment against the employer?
They simply had to prove that the employer was negligent, and that negligence was a cause of the accident.
Negligent to what degree? In other words, their wrongful action, any degree. And their wrongful action was to not notify CMP that there was a problem?
That, and to permit the employee, or to instruct the employee to unstep the mast in proximity to the line. That was their argument, that the employer was, and I have to admit that the employer probably was negligent. In an ordinary situation, there would be immunity because of workers' compensation. But under the law under the statute that is now under consideration, the liability would be question between the two, except of course for the employer's immunity.
Is there a legal, a statutory expectation of the utility to examine the condition of its lines, or does that fall upon, in this case, a private employer to do so?
There are regulations that require the line to be at specific heights in certain places. Therefore, it falls upon the utility to see to it that regulation is abided by. They can't do that without inspecting their lines. In the Brian Smith case, the utility was informed. The employer went to the utility, asked the lines be raised. The utility said, well, we'll do it, but you pay the cost, which would have been quite high. There was also another instance in which a sailboat mast came into contact with a line. Nobody was injured, but power went out on the peninsula for some time and had to be restored. That was because their line being too low. They had knowledge of their low line and they didn't do anything about it. Also, they drove by there every day and all they had to do was look at it and they could see what the situation was.
So the determination in that case, we're trying to avoid, wrongful results here, but in that case, the court determined that the decision on the part of the employer not to pay for the raising of the line was the prevalent fact in the case.
No, the basic underlying cause of, I say this, the verdict was based on the fact that CMP kept its lines too low. They knew that the lines were too low and they knew that it was in proximity to a sailboat and it was only a question of time before somebody got injured. And
I understand that's your argument, but the court wasn't sympathetic to that argument. Is that right?
That was the argument in the trial court.
Yes, and that's the trial court I'm talking about. Yeah.
There was a second case in which we didn't even make that argument because it wouldn't be relevant.
But in that trial court, the decision was made on the basis of what?
It was made on the basis of CMP's responsibility. The fact that they did not meet their responsibility, and that was a cause of the accident. That was the trial.
That's right. I'm sorry. The law court reversed. You're right. Okay. I appreciate that. I'm clear now. Thank you very much.
Law court reversed on the second case, but on the first case, the law court upheld the verdict.
Got you. Thank you so much for that. And I apologize for the time. Thank you.
Representative Moriarty, I know that your hand was up next, but you and I both have monopolized the questioning somewhat. So I'm just going to turn to Representative Poirier first and reach you in a moment. Go ahead, Representative Poirier.
Thank you, Madam Chair, and thank you, Mr. Mills, for joining us. I would just like to know in practical terms how this bill would affect real world situations. So had this amendment been in place during the cases that we're talking about, would the teenager that was electrocuted been able to still collect for damages, and how would the business in the subsequent case have been affected?
It would not have affected Brian's recovery at all. The first case, the results of the first case would have been the final result. There would have been no second case. There would have been no second case because the employer would be immune because of workers' compensation. There would be no second case.
Thank you.
Thank you for the questions and thank you for the answer. Representative Berry, I know your hand has been up and down. Go ahead.
Thank you so much, Madam Chair. And yeah, just as a refresher, the initial finding at trial was that CMP was negligent, disobeyed the law that lines had to be at 45.5 feet or higher. They were in fact left at 30 feet for many, many years illegally. And it was only this section of statute this bill is seeking to amend that then in the subsequent law court case allowed CMP to turn and put all that $6 million back onto, in responsibility, back onto the boatyard, because they were fully indemnified, unconditionally and fully indemnified by this portion of statute. So we're just seeking to amend that full indemnification and to limit the impact of that indemnification to the extent that if the owner of the lines is responsible, that they could still have to pay for their portion of the responsibility. Right now, again, it doesn't matter how guilty they could have put the lines at 2 feet and refused to move them illegally, and done so multiple times. It wouldn't matter, because as the law reads now, they're fully indemnified. So I think that's a public safety problem, because you have no incentive to, as a utility in this case, to do better.
Thank you. Thank you, Representative. That's a good, clear synopsis. Committee members, are there any additional questions for either Barry Mills or for the bill sponsor before we turn to our committee discussion? I am not seeing any hands up. Oh, Representative Moriarty, you're right. I promised to return to you and I did not. Go ahead.
It's okay. Thanks, Madam Chair. I wonder if Carlisle Tuggy is in the waiting room. She was present at our public hearing, but the amendment had so recently been introduced, she was not really ready to respond, but said she would be.
Thank you for that reminder. She is here. And Carlisle, I am going to bring you onto the panel, and I'm going to send Barry Mills back to the panel, again, with appreciation for your being here today. And Representative Barry, you're welcome to stay. Carlisle Tuggy, thank you so much for returning to our committee. I think we gave you some homework when we had the public hearing on this bill, and we asked you in particular to share with us CMP's views of the proposed amendment. Could you please share those with us at this point?
Yes, thank you. And it's a pleasure to be back. And I do just want to say that I hadn't had a chance to fully review the amendment that had been provided. So I really want to try to parse where CMP is, and it's different than what I was saying the other day after I took a hard look and also was listening to Representative Berry and Representative Sanborn about the heart of the concern that folks have both on the commission, this committee, as well as on the EUT committee. But just to briefly go through the questions that I think folks had was about, there were some questions about requisite pole height. So CMP is governed by the National Electric Safety Code, and we are required to be in compliance with that. And it is correct that we were not in compliance with portions of that at the time that this litigation occurred back in 2002. It is the case that we subsequently came into compliance. I would also note that the code regularly changes, and we are regularly accommodating those changes and assuring that the system is in compliance with pole heights. Pole heights can vary from 45 feet to 40 feet to higher or lower, depending on the terrain and the situation. The majority of the phase 3 lines that you see over roads are 45 feet. Single phase lines, which are smaller lines that might be in a neighborhood, are required to be at least 40 feet. And then lower would be, where you might have a pole right on a property, or there may be some other reason that we need to accommodate a lower pole height. But just to be clear, and as found by the court, we were not in compliance. Subsequently, we did do a full inspection, came into compliance, and since that time have been in compliance and also adapting to changes in that code as it has varied over the years. It sort of relates to another question that was asked about what's covered by the Overhead Line High Voltage Safety Act. And the act itself does define overhead high voltage line as 600 volts as the operative term. Generally, just to give you an example, like a low voltage line might be a line that connects the system to your home, where it's just literally bringing in the electricity from the wire on the street into your home. But so that would be low voltage and not subject to this act, most likely, because typically those lines are less than 600 volts. And then above that, going, all the way up to 1,000 volts and much higher, would be considered high voltage. So really the intent of the act is to capture, all of the major, poles and wires throughout the state, with the exception of much smaller lines that might run to a property. And then there was also a question, because I know obviously there's a lot of focus on this case, and this, I will elaborate also on our view of the case and the outcome and the amendment presented, but just to give you some other examples of instances where the utility could be found negligent would be where we've improperly installed equipment, where there's a lack of safety mechanisms that are required or that would be generally accepted in the industry, improper maintenance, lack of maintenance. You can imagine sort of any sort of situation where we weren't in compliance with the law or otherwise didn't act reasonably, and a court were to find our behavior negligent. So I just brought that in to show that it might be in instances, this really covers situations out beyond just a pole being the wrong height, which obviously would be significant and important. And certainly we could be found negligent if that were the case, but there may be other instances as well. And I can just continue and talk about our view of the amendment if folks don't have questions on that.
Yeah, if you could please move on, because I think that that's the most significant issue.
All right, let me hurry up then. I don't want time. I just wanted to go through the questions the committee had asked. So I think at the heart of the issue on the negligence is just this concept of fairness, and where you have unallocated indemnity and a party such as the utility did bear some responsibility for the situation, we were fully indemnified, and it doesn't feel right. And we are comfortable and don't oppose an amendment to this law that would call for comparative negligence. So where a court were to find that CMP was at fault and attribute some portion of that fault, we're in agreement. We should not receive indemnity for that portion of harm. So I just want to make sure the committee understands that I didn't have a full appreciation of the heart of that issue prior to coming to your committee the other day. I was explaining the intention of the unallocated indemnity, but that I think there's the middle ground from a public policy perspective where you keep the utility on the hook for the portion of the responsibility the court finds it owns and still not undermine the safety intention of the act, where the rest of the negligence would be supported by another party in the proceeding. As to the employer immunity piece, I think that's a little outside the interest in CMP's interest. So I don't want to venture too far there. I would just say that if you are to make employers completely immune, it may have an impact on their incentive to make sure the act is complied with. But I don't really think that was the aspect that CMP was asking about. So as to the comparative negligence piece, we're fully comfortable and, expect that we would be on the hook going forward where the court were to find us responsible for some portion of the injuries at hand.
Thank you so much for your answers to our questions. And committee members, are there any questions for Carlisle Tuggy? It looks like you have fully answered our questions. We appreciate you returning to the committee with that information today.
Great. Thank you so much. Take care.
You too. Okay, committee members, let's transition to our committee discussion regarding this legislation. Does any committee member wish to speak to your colleagues? Go ahead, Representative Moriarty.
Thank you, Madam Chair. I know we've sort of mentioned in passing a number of times the concept of employer immunity under the Workers' Comp Act. And I just pulled the act off my shelf, and it's clear and has been for decades that employers are exempt from civil actions involving personal injury sustained by their employees. So I think that immunity would have applied to the action that CMP brought against Devereaux. Second related point is, if you really want to create a hornet's nest, you would begin to tamper with that principle of employer immunity. That would set the session on its head, and I really don't counsel that you do that. It's a matter for, it would be a matter for labor and housing anyway. But when you think about some of the blow-ups there have been in workers' comp in the 80s and 90s and the shutdown during the McKernan years and so forth, you just don't want to go there. I'm really quite impressed by Carlisle Tuggy's testimony that CMP agrees that the comparative negligence statute really ought to have applied because it unfairly gave them full indemnification where in fact they were partially at fault. And so frankly, my bottom line is that Representative Barry's amendment is good and appropriate and addresses the anomalous issue that sort of the anomalous bottom line of this complex series of cases stemming from the electrocution. That's all.
Thank you. Can I ask you a question, Representative Moriarty?
Sure.
So is under the Workers' Compensation Act, would an employer be immune from a contribution claim, for example, by a manufacturer of a product where the employee sued the manufacturer and recovered damages based on a defective product? And then the manufacturer goes after the employer. Would there be immunity in that situation?
In my judgment, yes. And I'm looking at the statute, which is Title 39A, Section 104 for reference. If the employer has purchased workers' comp coverage or is self-insured, that employer is exempt from civil actions, plural, involving personal injuries, again, plural, sustained by an employee arising out of and in the course of that employee's employment. So it's not, I think the immunity does not apply just to the injured worker's potential lawsuit against the employer, but to any civil actions arising out of the injury itself. I think it goes that broad.
Thank you very much for that information.
Sure.
Committee members, any other discussion? Does any committee member have a motion? I see some other hands up. Representative Babbage?
Thank you, Madam Chair. I just wanted to be sure that I appreciated very much Ms. Dougie's testimony. But her supplemental testimony, I guess I'd say, are not directly at the interest of CMP, but thinking that removing addressing employer liability was beyond their scope of interest, but she talked about incentives. That is her comment was in reaction to our discussion, but not in reaction to anything that is before us. Is that right?
I mean, my assumption, if that's a question for me, the way I interpreted that is, and the law court decision talks a little bit about this, that the way the current statute is written, it incentivizes people other than the power company to maintain what I heard and was that the comparative standard is likewise an incentive. It's just an incentive shared by every party to the accident. It's a shared incentive to maintain safety.
So the implication was not that what is before us today in this amendment removes incentive in any way.
That's how I took it. I agree with you.
Thank you.
Yeah.
That was clarification for me. I appreciate it.
Representative Evangelos?
Thank you, Madam Chair. I'm going to move out to pass.
As amended?
Yes, as
Okay.
amended.
Okay, we've got an ought to pass as amended by Representative Evangelos. I see a lot of seconds. Representative Poirier, is that your second? Okay. All right, so we've got a motion on the table, ought to pass as amended, seconded by Representative Poirier, and a bunch of hands up, still, one of which is residual, I can tell. Representative Hagan, you have the floor.
Thank you very much, Madam Chair. I would like to request the corner caucus, just as you know, I've missed a lot of things, so I could have a little discussion with my folks.
Okay, so I would like to suggest we return at 3:20. That gives us about 6 minutes. Is that enough time, Representative?
I think so,
need
yeah.
more?
If it ran over more than a minute, then we just end it. So that'd be great. Thank you.
Thank you, everyone. We'll be back at 3:20-ish.
Did you caucus, Steve?
No, I assumed there was going to be one. So and last time they didn't caucus either.
Yeah. Okay.
So we didn't miss anything.
So it wasn't personal. That's what you're saying.
That's right. That's right.
Chris, this time we were in a caucus and you guys weren't there.
You were?
Yeah.
Committee members, if you're back, and our colleagues may still be caucusing, so we can give them a moment. But I would ask everybody to remind me when we've completed our work on this bill, that we do need to return to our first bill, because that was set aside, but there was no vote that could be taken because we didn't have a senator in the meeting at that time. So. Okay, it looks like our colleagues may need a couple more minutes. And I will return in just a minute as well, everyone.
Okay.
Peggy on right now? Peggy? Did you, I never did find the piece that you were going to post in the committee work. Did you get my other message that I couldn't find it, and would you send it to me?
I didn't see that message. I'll be happy to send you whatever you need.
Yeah, it's the one on place names.
Oh, the report.
Yeah.
Yeah, you know what? Why I know I emailed it to Representative Moriarty. I'll
Yes,
go
I
ahead
got
and
it.
email it to everybody. It is posted now on the reports page, but
Oh, okay.
I'll email it to everybody.
Reports.
Just delete your email if you don't want it.
Okay.
I'm muted. I'm back. Thank you, everyone, for your patience. Representative Hagan, go ahead. Representative Hagan, your hand is up. Did you wish to speak? You might be frozen.
No.
Can everybody hear me?
Yes.
Yeah.
We can hear you. We can't hear Representative Hagan, though.
Representative Hagan, did you wish to speak?
No, I'm sorry. I just lazily left my hand off and I had the computer muted, so I didn't hear anything anybody said. Sorry about that.
You said lots of nice things about you. Okay, committee members. Is the committee ready for a vote on LD 840? Appears that we are, and our wonderful clerk, Susan Panett, has joined us. You may proceed with the vote.
Thank you, Madam Chair. Representative Galgay-Reckitt,
Yes.
Representative Galgay Reckett votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Keim. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. I'll recall the absentees. Senator Keim. Senator Keim is absent. Representative Harnett. Representative Harnett is absent. Madam Chair, I have 9 members voting in the affirmative, 3 members in the negative, and 2 members are absent. That is the vote of the committee.
Thank you very much. And Representative Hagan, could you please let us know what your report is?
Oh, for now, it's just going to be ought not to pass.
And Representatives Thorne and Libby, is that the same for you? Yes. Okay, thank you all. And so the ought to pass as amended motion passes 9-3 with 2 members who will have an opportunity to vote over the next 2 days. And so with that, we'll close the work session on 8:40. And then we're going to reopen the first item in our afternoon work session was LD 480. And that is a motion that was, a bill that was set aside. And at this point, I guess I would just like to express that because I was absent for the work session, most of the work session on that bill, as was Senator Sanborn. I think she and I would both like some time to watch the committee tape. And so if it is acceptable to the rest of the committee, I would entertain a motion to table 480 and we can take it up at a later time. A motion to table by Representative Sheehan, seconded by Senator Sanborn. Committee members, if you are in favor of the motion to table, please raise your actual physical hand and keep it up until we've had a chance to count the votes on the tabling motion. Okay, it looks like we're going to need to do a roll call here. Soupy, could you please return? Since it's not a unanimous vote, I want to make sure that we get the roll call down. So this is on the tabling motion on LD 480. Thank you.
Thank you very much, Madam Chair. Representative Galgay Reckett.
Yes.
Representative Galgay Reckett votes yes. Representative Newell. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Keim. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
No.
Representative Libby votes no. I'll recall the absentees. Representative Newell. Representative Newell is absent. Senator Keim. Senator Keim is absent. Representative Harnett. Representative Harnett is absent. Madam Chair, I have 9 members voting in the affirmative, 2 members voting in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much. And so the motion to table carries. And so we will resume our work on LD 480 at some point in the future. And with that, we've closed the work session on 480. And I think that that finishes up our work for the day. I know that we start up tomorrow morning with a 9 o'clock public hearing on LD 1310. And before we say adjourn, are there any committee announcements from our OPLA staff or our clerk?
I have one, and
Okay.
just that LD 1310, which is the bill at 9 o'clock tomorrow, is a concept draft. Representative Talbot Ross has put together a proposed committee amendment that would replace that concept draft. It's loosely based on LD 1459, which creates a criminal records sealing process, but it's kind of a more streamlined bill, and it takes into account recommendations from the criminal law, the committee to review criminal records. And I have emailed it to you. I haven't posted it in the portal yet, but I will do that as soon as we're done here. And I've sent it out to the interested parties. So the hope is, although it's very short time, the hope is that that's what the hearing will be on, is that draft and any other comments from the Criminal Records Review Committee.
Thank you, Peggy. And just a quick follow-up question. Was it just because it will help us find it in our email? Did you send it out today or yesterday?
I sent it out today, this morning, maybe between your hearing and your work session.
Great. Thank you so much. Okay, so committee members, just be sure to check that out. And with that, is there a motion to adjourn?
So move.
All right, by Representative Thorne, seconded by Representative Sheehan. And we are adjourned until tomorrow. Thank you, everyone. Have a nice
Thank you all.
Good night,
Have a
all.
good night.